कल मंडे कर
Where we permitted to mention, my lord. My lord, these are the hearing matters arising out of the motor accident claim case, my lord.
you.
My lord, the matter is ready for hearing. Everything is done. The paperwork is also ready.
But the other side is to come.
My lord, we have already notified the other side as well. My lord, kindly list the matter on any day according to your convenience, my lord.
Tuesday, Monday रख दो. तो असाइन नहीं तो बेटा हमारे मुझे बोले थे सिविल लेते हो.
My lord.
Will also be permitted to mention a matter for inclusion or extension of interim order.
When the interim order is going to expire?
It is already expired due to certain due to election. The petitioner couldn't come to formation. I'm filing a condemnation of delay with the
condemnation delay of
Section 5 and extension of interim order application.
You tell me all persons are telling in extension of interim order. You know which date your interim order is going to be expired. Why you persons are filing the CAN application? Why you are not mentioning before 2 days before the circuit for extension of interim order? All because all it is nothing but increasing of the pending cases. You all persons, you know, yes, 30th May is the interim order is going to be expired. Why you are not mentioning when this when the circuit bench before 2 days of the circuit bench is over? See, I find that several applications for extension. Give.
My lord, may I seek your lordship's leave, my lord, to mention this matter? My lord, this was running as item number 82 in your lordship's yesterday's cause list. But today this is not running in your lordship's daily cause list. My lord.
Yes, and it will come Monday.
My lord.
Why mention it? It is in the list, na?
My lord. It was there in the list, my lord. Today it is not there.
It will come tomorrow. Yes.
May I have your lordship's leave in my lord? I am presenting physically, my lord, before your lordship. So, my lord, for inclusion in your lordship's list, CRR 106 of 2026 for the extension of interim order that has expired on 4th of May 2026. My lord, I am just giving you the slip just within the due course, my lord.
Yes. Item number 1. Record. The matter was listed on 14th of May 2026, but none appears on behalf of the petitioner. No accommodation was sought for. But for the interest of justice, case was adjourned till today. Today also, when the matter is called, none appears on behalf of the petitioner and no accommodation is sought for. This accordingly, CPAN 3 of 2025 in WPA 1032 of 2024 is dismissed. 3. Also, 4. Yes, who is for the petitioner?
Yes.
Why? Huh? Who is the senior? Huh? Yes, you are appearing for?
Opposite party.
Paso. 6. Paso. 7. Paso. 8. Paso. 9. Yes. Paso. 10. Which matter? 10. 283. Yes. Huh? 282. You are for the petitioner. Which for the state? Have you served notice?
I was,
Are you present?
yes, I think they will have, it was delivered.
Yes, who is appearing for the Pradhan Nagar Inspector in charge?
Yes, sir.
And you present? In which matter you are appearing?
So that time I was not interested.
Which matter you are appearing?
Regarding, sir,
Which case?
also electric.
Now, which case? Case number? 252. Huh?
19.
And 252? 252 of 26?
Oh, sir, Ayub has come. Ayub has come. तुम्हारे को तो नंबर कैसे? Next one. Oh, 252 come. 252.
You are,
Ayub? Sir.
you are you?
Sir.
Yes, what is the case?
In this case, Nara, the complainant is the wife. And the complainant.
What is the section?
Actually, it's 498, 323, earlier it was 326, and
498?
and 468, and 463. Forgery, allegations, facts of allegations that husband and wife set up is
Huh?
husband. De facto complainant is the wife,
Ah.
and one Trilok Sonar is the husband. They married 1999, and child brought up thereafter in piece of land, set up a small school. PS14 is the camera. And thereafter, she also working in the school. And thereafter, husband, the pollution came back, and there is a dispute, matrimonial dispute occurred, and wife left off from the school. And thereafter, on matrimonial suit also filed. And only allegation is the present petitioner that they humiliated the de facto complainant. They are the present petitioner of this working staff. One, two and three, according to them, and four is the secretary of the school. Most specific allegation, only allegation is only humiliation is the facto complainant.
স্ট্যাটাসটা করেছে স্যার সেশন করে বেল 26 বেল বেল
Criminal complaint lost by the wife.
রিজেক্টেড হয়েছে সেশন স্ট্যাটাস আছে সেশন শুধু বেল রিজেক্টেড
Yes. What is the stage of investigation?
Yes. Sir,
You're appearing, Mr. Banerjee? Yes.
My lord, actually, there's an instruction from the LR department, which was secretary on the last occasion I've told. He told me that the state should not be 100% and still my cancellation or the new notification, I should be here. So that is the authority, appointing authority has told me. Now that's why I'm helpless. So I have to appear on behalf of them. Madam.
That's
I have to
why.
help the prosecution.
See, the court is not
Yes, yes,
interested.
my lord.
Court
My lord.
wants that somebody should be represented to the state, either you or that person, whatever it is. If you are appearing, then there's no problem
This
at
is the
all.
original CD, my lord. The memo of evidence is there.
yes,
কেস রিজেকশন হয়েছে
এটাই বিহার
This is the memo of evidence. And my lord, being an experienced judge, not only my lord, you have already, as an APP, you have served for the state, my lord. My lord knows better than me.
No, see, okay, it depends upon.
But regarding my lord, this is different because rest of the other my lords, that is different. But my lord has an experience of being an APP of the Andaman High Court, my lord. So in that case, we have seen my lord. জিজ্ঞেস করলে আমার উপরে এটা কোনটা?
এটা আমার ওই এটা ওই বক্সের
আপনার কাগজ?
এগুলো
Is there any documents is with regard to the misappropriation of the money?
Misappropriation of the
Any
No.
document you see, because the main allegation
No
that
documents.
the husband and the
seizures.
other persons have misappropriated the money of the school. Have-
সিজার লিস্ট আছে স্যার
Huh?
Caesar list is there.
Huh?
সিজার লিস্ট
is there.
No, misappropriation of the money, have you got any from the?
সিগনেচার অনলি ফর স্যালারি সিগনেচার
Not salary signature, the accounts, have you accounts have been seized, whether they have misappropriated the
No.
money from taking this?
না অ্যাকাউন্ট সিগনেচার নেই স্যার
nahi.
নেই স্যার
Husband have taxes, there are.
সিগনেচার করে কোনো
এবার শুধু স্যালারি
এক্সপ্লোরেশন করেছে কোনো কন্ট্রাক্ট ওই মহিলা
অ্যাকাউন্টে স্কুলের রেভিনিউ স্ট্যাম্প আগে যেটা অ্যাকাউন্ট
How much money you have misappropriated? Nothing. So how the complaint?
In February 25, my husband filed matching.
Have you not seized the accounts?
না স্যার
Why accounts registered you not
না
seized?
অ্যাকাউন্ট ছিল না স্যার
Chilo na?
No.
Account আছে না?
অ্যাকাউন্ট দেই নাই স্যার অ্যাকাউন্ট থেকে স্যালারি রেভিনিউ স্ট্যাম্প দিয়ে স্যালারি তুলতো স্কুল
Only her signature was forged by her husband.
স্যার
So whether
So
the
this is the
signature,
allegation?
have you taken the specimen signature of the complainant and the accused persons?
It's a for anticipatory ballot.
No. Have you taken the signature of the accused persons? Have you issued notice to the accused person to appear for taking the signature?
সিগনেচার নেওয়ার জন্য
সিগনেচার এখন অ্যাকুস্ট করা হয়নি স্যার
কম্পেয়ার করার জন্য
Have you issued notice?
This is a case of 5th April 2026.
So what is your submission? What do you want to say
Custody
regarding investigation?
ইন্ট্রোগেশন দরকার আছে স্যার এটাই
Custody
সেশনে বেল
reject হয়েছে বলে আসছে। And the complaint was excluded from all school meetings and her husband even forged her signature on all school related documents. Additionally, husband forged her signature on the authorization letter of the school vehicle Using school funds, her husband travel abroad on numerous occasions. After all this, each of the alleged accused persons continue to insult and humiliate. These are the allegations.
You not see where is the receipt which they have withdrawn the money? You
কোথায়
not
আছে?
see the
receipt আছে?
receipts?
Withdraw করেছে টাকা সই করা?
না
শেষ করেননি?
ওটা
ওনার
তো দেই নাই
হ্যাঁ?
সিজার লিস্টে আছে ওটা পাওয়া যায়।
না না, যে ডকুমেন্ট রিসিট গুলোর মধ্যে সইটা জাল করেছে সেই রিসিট গুলো পাইছে?
Fine.
My lord, it has not been collected.
Yes,
Then I met to,
maybe.
we are the school teacher, kindly see, they send.
How many petitioners? Who are they? Who are they?
করেননি কেন?
এটা স্কুল টেস্টার তো স্কুল থেকে দিতে হবে।
হ্যাঁ, নোটিস করতে হবে না?
Who is the husband?
আপনি প্রথমে সিজ করে জেরক্স করে জিম্মা দিয়ে
Who
দিন।
are they?
Number one is the principal of the school. Who are the working staff, accountant, and four is the managing committee member. Kindly.
Where is the appointment of the petition number one as a principal? Private school, you might have been appointed. Where is the salary certificate?
Kindly see the, they send legal notice, I also reply to the legal notice, thereafter this legal complaint, my lord. It shall salary or nothing.
সেকশন নাই সেকশনটা তো নোটিসেবল এগুলো দেখছি ভেরি নোটিস তো
Kindly observe.
ইভেন নোটিসটা দেন। নোটিস না,
Section
7
নাই,
years years।
আবার 7 years
Husband and wife.
Where is the husband?
The husband is there, but not with me. Will be staff, we prepared an application to the session there. There was.
You're taking the chance. They will get the anticipated, and he will come with the second application. Yes, the other accused persons have.
This submission, my humble submission, kindly consider, case 70 husband file match, thereafter,
Husband, and here is the staff. Their staffs are not cooperating with they are not producing the.
We are within the school, day to day working. Why I am not cooperating? If you are not directed tomorrow, I will meet the investigating officer, my lord. This page 19, my lord, page 19, they send legal notice. Can you see, my lord? And page 22, we reply.
Who has issued the notice?
On behalf of the, my lord, legal notice sent by the de facto complainant for payment of money. Page 19, my lord. And thereafter, page 22, immediately we reply. My lord. I annex the, my lord, FIR, my lord. And thereafter, husband file match, thereafter, this detailed complaint. Kindly consider, my
এটা
lord,
ব্রিফ আছে যে মানটা করছে।
that the staff member, husband wife
আচ্ছা
dispute,
নিশ্চয়ই।
they, our implicated in the instant case, my lord.
নোট করে রাখো। এর আগে একটা জিনিস আছে। এটা জাস্ট একটা ভিতরে নোট করে রাখো।
After filing of the first,
প্রধান না বলতে কি
he can thereafter create a story and lodge his complaint, my lord.
252
I cooperate with the investigating agency, my lord. Any stringent condition, my lord. Paragraph 23 of the FIR says that it insulted individually mentally for criminal crime. Must be the allegation, my lord. You will cooperate, my lord. Kindly, my lord. Consider, my lord.
Who is the petition number one?
Question number one, become a principal.
How he became a principal?
Right, it's small to white.
So that is the allegation. You have been pretended to be a principal of the school. Who has established the school?
Husband and wife,
So how you become the principal?
she resigned from earlier.
So she resigned from earlier. So who has appointed you? How you are connected with this business?
And the salary member, my lord.
And who is the petition number two?
সার্টিফিকেট কপি নিয়ে
They
গেছে।
are the staff.
এক্সট্রা কপি নিয়ে গেছে।
না
What is staff? What accountant? 2, 3, and 4.
And 4 is the managing.
So, where is the managing committee? Why you not issued the notice under?
No, notice the sections, those are more than 7 years punishment.
No, not that. With regard to the
Documents,
Yes.
production of documents.
Yes, production of
My lord,
document
my
from
lord,
the.
this case was started in 5th of April. After
My-
that, my lord, assembly election. My lord, we should be given the prosecution has to be given some time for investigation. my lord.
The petitioners have filed the present application for grant of anticipatory bail in connection with grant of anticipatory bail. The counsel for the petitioner submitted the petitioner number 1 is the principal of the schools, and the petitioner number 2 and 3 are the accountants. 2 and 3 are the accountants, and the petitioner number 4 is the managing committee member of the school. Now, counsel for the petitioner submit that there is a dispute between the de facto complainant and her husband before initiation of the present case, the de facto complainant has issued legal notice to the school as well as the accused petition number 1 to the petition number 1 claiming the amount, and when the amount was not paid, the complainant has made a false case before the police authority. And counsel for the petition submitted this is the dispute between the husband and wife, and the petitioner has no way connected with the dispute. He submitted the petitioners are the employee of the school, and as such, and still they are attending the school and performing their duty. They have not absconded from the places, and they have not absconded even after the registration of the FIR. He further submits that if the anticipated bail is granted, the petitioner will appear before the investigating officer and will cooperate with the investigation. Leonard, APP in charge, along with the IO and the CD is present. Along with the IO is present. Full stop. The IO has produced the CD. This court find that the investigation is still going on. Full stop. The several record is required to be seized from the school, which can be for proper investigation of the matter. He's the investigating officer.
One indulgence,
The FIR has been registered.
My lord, 2-3 documents has already been seized. These are the authorized letter, my lord. I'll just take the that is there. आपने बोले अच्छे.
Account? There is no account.
No, seizure is ताकि बात करो.
Yes, 20.
अरे अपने कागज में बात करो.
I have these authority. They pay 5,000 per month. This amount rent not paid. No other misappropriation in the legal note.
But the complaint, see
But
the
the complaint is in here.
Then
This is my one chance legal note. Kindly consider one.
My lord, this is the signature, the fourth signature, my lord. This has been given to the bank, my lord.
My legal notice one.
full stop. क्या बोला? The PP in charge along with the IS present, IS produced the CD. The PP in charge submitted. The case has been registered on 5th of April 2026, and in the meantime, there was an assembly election, and all the police authorities are busy in the assembly election, and as such, the investigation could not be progressed further. Now the investigating officer will collect all the documents to further process of the investigation. He further submitted for all the documents are lying in the school. All the documents are lying in the school. And as such, if at this stage the accused persons are released on bail, there is every apprehension that the accused persons will hamper and tamper with the investigation. Heard the learned counsel for the respective parties for using materials on record, and this could find that it is a specific allegation in the complaint that the accused persons have misappropriated the money of the school by forging the signature of the de facto complainant. The investigating officer yet to seize several documents to process the investigation, and as such, this court did not find any any merit in the present application to allow the petitions to go on anticipated bail according to the anticipated
Madam,
bail.
I will cooperate any stringent condition.
Rejected.
They are the innocent
Sorry,
employee, my
come with a
lord.
good case, come with a good case.
Innocent employee, husband, wife dispute, they, my lord.
Next.
Must.
11.
And for the petitioner, madam. I'm moving this case for the first time, madam. The CD is required.
Present.
The 490.
CD is there, madam.
498, 406.
Who is the petitioner?
My lord, the husband and the mother-in-law, my lord, no 41 year notice still to be given, my lord, the
Husband and
mother-in-law. The husband
mother-in-law.
has first filed a void marriage case, my lord,
Huh?
void marriage case,
What marriage case?
void marriage. The-
Void marriage.
Yes.
Ah.
Yes, my lord. The de facto complainant, my lord, was previously married. And suppressing that fact, my lord, she married the present.
You moved yesterday one
Yes,
application.
yes, my.
Hmm.
That case itself, my lord.
Hmm.
Suppressing that fact, my lord, she filed the FIR, my lord, and this FIR must be lodged after a delay of 6 months, my lord.
Yes, Mr.
কোন থানা এটা? মিরিক PS?
Please, please.
But I'm holding the CD, my lord. মেমোটা remove. কি হয়েছিল রে?
One 164 recorded.
It's a case under section IPC 498. My lord. Thing is that, my lord, serial number 1, Shubham Agarwal and Byron Pradhan. They are actually the resident of, though it's written in Mirik, but they stay in Nepal. So in that case,
They are not staying in Nepal. It's written in the FIR itself. They run a school in the name of BL Memorial School premises at Panighata. They run a school over there, madam, and they stay in that school itself. There is a premises over there, and it is written in the FIR itself, madam.
Where you reside?
It's written in the FIR. BL Memorial High School, Panighata, under Panighata Police Station. It's written in the FIR itself, my lord. Page number 8 of my application, my lord.
Yes. Complainant herself was given the residential address. What is the name?
Shubham Agarwal is the principal accused
Principal.
person, and the mother is Mayarani Pradhan. Regarding these two accused persons, as per the information from the IO, my lord, they are staying in Nepal, okay, whatever it is. So in case if any protective order is granted, my lord, in that case, their attendance should be required.
They have to appear before the investigating.
Yes, my lord. Because otherwise,
Their
if they go to
presence-
Nepal, if they.
Presence is required, so they will appear before the investigating officer.
Sir,
once
the
in a week.
investigating officer till today did not give 41A notice. Repeatedly, the petitioners have gone to the police station and sought for a 41A notice, my lord, so that we could secure the bail from the lower court itself, my lord. For such cases, my lord, there is no requirement of anticipatory bail, my lord. And your lordship has passed an order, my lord, in that regard. I remember, my lord, in the previous.
The petition has filed the present application for grant
He
of
is for-
anticipatory.
Bar-bar get a police station.
The petition number 1 is the husband of
I cannot
the
doubt.
de facto complainant, and the petition number 2 is the mother-in-law of the de facto. Counsel for the petition submit that. Counsel for the petitioner submit that the de facto complainant had prior marriage before the marriage solemnized between the petitioner and de facto complainant. When the petitioner came to know, in the meantime, the de facto complainant has filed an application for declaring her first marriage null and void. Immediately when the petitioner number 1 came to know about the same, the petitioner number 1 has filed a suit for declaring the suit as null and void, and declaring the marriage as null and void. When the de facto complainant came to know about the same, the petitioner and the complainant has made a false complaint against the petitioner as well as the mother-in-law. When a counsel for the petitioner submitted the that till date the investigating officer has not issued the notice under 35(3). 35(3).
35(3), my lord.
35(3) of the BNSS. We submit that the petitioners. The petitioners submit the petition, the land council for the petition submit the anticipated bail is granted, the petitioners will appear before the investigating officer and will cooperate with the investigation. Land council for land APP in charge submit that still the investigation is going on. Police stop. He submitted that the petitioners are not the resident of Mirik, they are the resident of Nepal. And if at this stage, if anticipated bail is granted, it is not possible for the investigating officer to proceed with the investigation. Police stop. He pressed the IU has produced the CD, wherein it reveals that the 164 statement of the victim and the mother of the victim has been recorded and investigation is going on. At the landed council for the respective parties peruse the materials on report. This could find that there is a matrimonial dispute between the petition number 1 and the de facto complainant, and the statement under section 164 of the CRPC has already been recorded, of the victim as well as the mother of the victim has already been recorded. This could find that there is no necessity of custodial interrogation of the petitioner. Accordingly, if in case of arrest of the petitioner, the arresting officers have released the petitioners on bail, on furnishing bond of rupees 10,000 with one surety
So it
each.
can be 5,000, my lord.
You need not to deposit the amount,
Then
5,000, 10,000 with one surety each. If police stop, with the condition that the petitioner shall appear before the investigating of petition number 2 is the lady. The petition number 1 shall appear before the investigating officer twice in a week.
Once in a week, my lord, once.
Twice in a week until further order. Full stop. The petitioner number 2 shall appear before the trial court on each
She's
and
a
every date
mother-in-law,
of
she's
hearing
old lady,
without
ma'am.
fail. Date of hearing without fail.
I'm grateful.
CRM
I'm
said
grateful.
so, CD is written.
Great.
Next, CD.
Well, just a minute. This is Shubham Ghosh.
Shubham Agarwal.
Shubham
Shubham
Agarwal.
Ghosh to- That's 11, item number 11.
11. It दो CD दो केस दो केस रिकॉर्ड दो केस रिकॉर्ड दो
Shubham Agarwal.
Thing is that cause list, our serial is 10.
10, it is 10, madam. It has to be 10.
ना 11
No, in our cause this is.
I do not know, there is a different, yes.
Previously cause list download করে নিয়েছো।
अच्छा वो that has been rectified. You
Yes,
have
my lord. Yes, my lord.
Yesterday night there.
yes, it is 11. 11. Next.
12. Or I am for the petitioner. In this matter, victim is required. I already served the victim, but it is yet to be effected.
Huh?
I served the victim.
To whom is how it is served? Where is the affidavit?
To post, my lord, I have.
Where is the affidavit?
My lord, it is not effected yet. That is why I did not make the affidavit of service. Now let it be any day in the next week. I will do the matter.
Then a counsel for the petition submitted, notice could not be served upon the victim. Accordingly, press for adjourn, let the matter appear on 20th May.
So as per guideline of
Next.
Supreme Court, it came from the defective.
13.
My lord, I have
They
the
will
petition.
they'll send notice.
My lord, this is a case under section
You can.
326 and my lord 307. My lord, petitioner and informant.
326 of the IPC
Yes, my lord.
or
326.
BNS?
326 and 307 of the IPC. My lord.
IPC.
My lord, petitioner and informant are the next door neighbor. My lord, long standing. There is a civil dispute. My lord,
What is the injury? Where is the injury report?
My charge sheet has already been submitted. FIR.
Where is the injury report? Charge
Malad,
sheet is
এটা আপনি
submitted.
কি
Where is the
তেমন
injury report?
My lord, I don't have collected the
Which
injury.
part of the body the injury was?
My lord, in the
Finger?
finger, my lord.
Chopped?
So far my instruction.
But
Which finger?
My lord, I don't know. Only in the FIR it is.
You file the anticipatory bail. You
Ah,
don't know
My lord,
which finger.
I did not chop the finger as because my lord kindly come
You
to
did
page.
not chop the finger because could have been gone through the
No, my lord, kindly come
the
to
trial
page.
court record.
My lord, kindly comes to
Yes,
page number.
Mr. Ben, you are appearing.
My lord, kindly comes to page number
yes, I have the
15.
memo of evidence.
13.
At the time of
You are having injury report.
I have not gone through the CD, my
My
lord.
lord, at the time of incident, my lord, I was in a different state, my lord. I as a migrant labor, I was worked there in Chandigarh, my lord. Page 15 is my lord, my employment certificate collected from my employer, my lord.
So your name is in the voter list? No.
No,
So how you will appear before the,
no, in the
Court.
voter list. So far, I don't have such instruction. My lord.
where is the injury report you are having?
My lord,
What
I
is
think
the
yes, it's in the record.
investigation completed.
Investigation completed. My lord, page
Charge
30.
sheet number 77.
How many victims are there? Injured person? One.
Is the, how many petitioner here?
My lord, only one. Four
There
accused.
are 2 accused persons.
No, Lord, here is the one
Four.
accused person.
There are 3 accused persons.
No, my lord, there is a name is so many.
Huh?
In FIR, there is a 4 accused person. Other 3 have been granted bail. As per my instruction, here is a 1 accused person. My lord.
Other 3 granted bail.
So far my instruction, my lord. But I did not have any order.
Lord, we have the
3 are absconding. 1 has granted bail.
injury report and the medical prescriptions are there. my lord. কি নাম? Injured?
Petitioner Sohidul.
না, injured.
Injured lovely BB, my lord.
Shoidul Mia.
Yes, my lord.
He is the main accused.
He is the principal accused as per the FIR, but my lord, I was not in.
And she was admitted, the discharge certificate is also there. Admitted for a long.
Charge sheet has already been submitted. Any condition, my lord, kindly consider. I was not even in the resident, my lord.
He was attacked with sharp cutting hooks and mallet and iron rod. Bleeding injuries were there. Over head, my lord.
Yes, my lord, if you lordly kindly see the FIR.
Over her head and body. And one of the fingers of left hand has been cut and fell down from her mane. My lord, this is a dislocation of the finger also, my lord. It was cut and it fell down, my lord.
My lord, kindly comes to page number 15, my lord.
আগে
time of-
reject হয়েছে না?
No. Reject all the file করতে পারবো না।
Interim ছিল না?
না, না। Fresh case. Without rejection of the file করতে পারবো না।
Who has assaulted? Who has assaulted? Where is the
Sir,
evidence?
164 is there, my lord. It's in the, it's written in Bengali in the memo of evidence also, and it's in the record also. শহীদুলের সাথে, may I read it, madam?
Yes.
ওদের সাথে আমাদের আগেই ক্যাচাল ছিল, 9 মাস আগে এই নিয়ে ঝামেলা হয়েছিল। কিছুদিন আগে রাত্রিবেলা আমি যখন নিজের বাড়িতে গরু বাঁধি, যখন আমি ঘরে যাই দুধ গরম করতে, ঘরের থেকে যখন আমি বাইরে ফেরত আসি, শহীদুল জানার বাইরে দাঁড়িয়ে আছে। আমি যখন ওকে এই ব্যাপারে জিজ্ঞাসা করি ও কেন দাঁড়িয়ে আছে, তখন ও ছুরি দিয়ে আমাকে আঘাত করে। শহীদুলের সাথে মিন্টু, জানাব ও শাহজাহান ছিল। আমি চিৎকার করলে আমার ছেলে ঘরে পড়ছিল, সে ধরে আসে। সে আসলে আমি তাকে বলি যে এরা আমাকে মেরেছে। আশপাশের লোক জড়ায়, তখন ওরা জায়গা ফেলে চলে যায়। ওরা আমাকে চাকু দিয়ে আঘাত করেছে, তাতে আমার ঘাড়ে, মাথায়, পিঠে বিভিন্ন জায়গায় জখম হয়েছে এবং সেখানে সেলাই পড়েছে। আমার বাঁ হাতের একটি আঙ্গুলের সামনে কেটে বাদ দিতে হয়েছে। So sir, serious
He is the
allegations.
main accused.
My lord, as per their.
A lady has been attacked in such a way.
My lord, local people was went there. My lord, kindly see. Any
Yeah, what?
independent-
But no, but
I was
there are
there
3
on-
injury. There are injury. Here,
Yes, my lord.
here, and the chopping of the lady finger.
I am not.
All are near the neck.
Page number
See,
15, my lord. At the time of incident, I was in Chandigarh, my lord. I am a migrant labor. But also see, my lord, any independent witness, my lord. 161 or
Page number 15.
150.
But that at the time of trial,
That
whether
will
the
be done
certificate
at
which
the
was
trial.
brought, who has issued the certificate has to give his deposition, my lord.
The independent witness, my lord, whether I was there or not.
Go surrender.
My lord, charge sheet has already been served.
Yes, go surrender.
Charge sheet cannot be a ground
Injuries.
for.
Injuries of
Cannot give any protection to the-
what protection? No, no, no. You're absconding. The petitioner has filed the present application for grant of anticipatory bail. The allegation.
General
grant of
number, দিয়ে দিত।
anticipatory bail. The police of PS Sita Kulchi.
এটার নাম তো বলে দিয়েছেন তো।
Sital Kulchi has registered the case against the petitioner for the offence under section 448, 326, 307, and 34 of the IPC. And counsel for the petitioner submit that the investigation has been completed, charge sheet has been filed, and as such there is no necessity of the accused, there is no necessity of the custodial interrogation of the petitioner. He further submitted the
সিআরএম
on the alleged date of the incident, the petitioner was not at the spot and he was the migrant labor and he was engaged,
in all items, in all
he was employed
in all items.
as security guard at Chandigarh, at Chandigarh, at Chandigarh. Police. The and consider the learned APP in charge has produced the CD and submit that the petitioner is the main accused who has assaulted the victim with the knife, due to which the victim has sustained grievous injury, and she was also admitted in the hospital. Police. She submit that in the 164 statement, the victim has categorically stated that there was a dispute between the petitioner and the victim, and the petitioner has assaulted the victim with the knife along with the other co-accused persons. He submitted though the investigation has been completed, but the injury sustained by the victim is at front temporal region, ear, and in the left shoulder. He submitted if victim has been, however, the victim has been saved, otherwise the victim succumbs to the injury. Police. He prays for rejection. Until and counsel for the respective parties published in notice on the court. This court find that though the investigation has been completed and submit charge sheet, but the injury sustained by the victim is grievous, and one of the injury is at the superior frontal temporal region, and as such, taking into consideration of the injury sustained by the victim, this court is not inclined to grant an effective bail at this stage. Accordingly, CRF number so dismissed. All the pass over.
Passed over matters. Item number 3.
Number 3.
Yes, who is appearing for the petitioner?
Sir, আগের সিট।
হ্যাঁ, আগের সিডিটা
Nobody.
মালাডা
Three.
4 now cause this has been changed. What is the name of the petitioner? Item number 3. 3 is Nilkamal Rai.
No, Chandrapal.
না আমাদের এখানে
3 is the Chandrapal.
Item number 3 তে কি আছে?
Chandrapal.
Oh, Chandrapal. একটু দাঁড়ান। Chandrapal, no one is
None
there.
appears on behalf of either of the, none appears on behalf of the petitioner. For the interest of justice, case adjourned, let the matter appear on 20. Next. 4,
For I am for the state malad, I am holding this CD malad.
Nilkamal Roy.
See, first I want to make clear. Till today, either warrant has been issued and either I am proclaim offender in this case. And first of all, you know, we have to.
What is the case?
There are two details, Lordship. Just permission of the learned court, I want to read the FIR.
164 আছে না?
চার্জশিট হয়ে গেছে?
চার্জশিট হয়ে গেছে। 19 কেস, 19
Yes, Mr. Banerjee. How, Chakraborty, Mr. How this 19? Why? The case is registered 19.
It's a case of 2019, charge sheet was filed in 2021.
20.
And
He is the named accused person in the FIR.
No, sir. One person only was offended.
So
Vishnu
subsequent-
Burman.
Vishnu is the
Defendant.
principal accused.
He has been granted bail.
No, Vishnu is not arrested, sir. Only subsequently, ma'am, four accused persons are unearthed. Among them, one person arrested.
Hmm.
He is Gaurav. And after arrest, sir, he was placed on TI parade and victims identified him. And subsequently, charge sheet was submitted showing raised accused persons absconding, sir.
Man accused Mohammed Habibul, who has committed again there, has been granted anticipatory bail by the Senate. And I am putting lesser than that and you say
Exception আছে
public right on.
দুবার রিজেক্ট আছে এক্সেপশন করে আপনার পরিষদ তখন বেল হয়েছে হি নোজ
Public right.
Huh?
Raise me only education is outer.
Sir, first of all, you tell me how many accused persons have been charge sheeted.
In the FIR, first only 3%, after charge sheet 2% has been included.
How many total?
5.
5 out of the 5, how many persons have been arrested?
Only 1% was arrested, Gaurav Rai, and he has been released on regular basis.
Correct.
And 2% was has been charge sheeted. Mohammed Habibul, these are with Gaurav Rai, self-putting. Gang rape. He has been granted bail.
Who?
That is Mohammed Habibul.
Mohammed Hafizul. Where is the order of the Mohammed Hafizul?
Case number, Lordship. Section 11.
জানি জানতাম না পুরোনো কেস ফলো আপ রাখা তখন আমি ছিলাম
Where is the charge sheet?
There was
last page of the CD, madam.
What is your name?
in a fact, common law, but my original name is Neil Kumar.
Neil Kumar.
Yes.
You have stated in the charge sheet with regard to these two persons only the outrage of modesty.
Outrage of modesty.
So how
Even in
this-
the report we have stated that. Today the report we have
But-
filed.
but-
there are two victims, my lord.
Correct, but this is
One was raped and one was molested.
correct. As per your
Against this-
knowledge, they are only the molested.
Kamal and Pratik Rai, Kamal means Neil Kamal. Against them only outrage of modesty.
Outrage of modesty.
Yes.
So what is the sex, sir?
8
Huh? How the 8? I will come.
that time, sir, I was not IC. It was an old case.
Old case.
Yes.
Yes, what is the submission?
Lordship, in gang rape kindly comes to section 376B. Lordship.
I will come to subsequently 2019. Other persons have been arrested
Lordship,
and
we have filed a cancellation with regard to
that may be,
Yesterday, Lordship
let
has-
me take into consideration. Yes.
Lordship,
But against this, there is no case of the gang rape, only the modesty.
Lordship, that is why I am bringing your attention of this court to section 376D
Of the?
of IPC.
376
C,
B.
which defines gang rape.
Sure. Are you sure? 376 B.
D,
D. Yes, gang rape.
where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offense of rape
Correct.
and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life and shall so that those persons who have not committed rape but has acted in group shall be deemed to have committed rape.
Correct.
So the sections of rape it cannot be said that they are only committed the offense of molestation. They have committed the offense of rape as well. That too a heinous offense of gang rape.
POCSO line?
Yes, Lordship, I want to be at the petitioner, Lordship.
Yes, what is the section?
Lordship, under section BNS, Lordship, 221, obstruction public servant in discharge of public functioning, Lordship, and Lordship 307-2 and 317-4, Lordship. Dishonestly received the stolen property, Lordship. Dishonestly.
Under section 221.
Yes, Lordship.
What is the IPC section now?
186 Lordship.
Huh?
IPC 186 Lordship.
186 public servant.
Yes, Lord.
3032,
379 Lordship. Theft Lordship.
379.
Yes, Lordship.
Then 372,
411 Lordship.
for receiving property,
Yes, Lordship.
stolen property.
And
And 3 by 5,
common intention Lordship.
huh?
Common intention Lordship.
Common
34.
interest, 34.
Yes, Lordship.
Yes. What is their allegation?
Lordship.
How many accused persons? All.
No,
File
Lordship.
the application on behalf of?
4 accused person Lordship. There is a
How many accused persons are involved?
11 accused person, and thereafter Lordship the obstructing the public servant Lordship on 2 Lordship. Lordship, kindly come to page number 11. This is the FIR Lordship.
Who is appearing for this? You are appearing, Mr.
I is present with this audience.
Lordship, the number of the serial number of the 7, 8, and 9 and 10 Lordship. This is the petitioner Lordship.
Serial number
7, 8, 9, and 10 Lordship.
8,
Yeah.
9, and
10.
10.
Lordship, allegation is that at the time of searching Lordship, the 5 cattle was recovered from the house of the HON'BLE Lordship. He was the granted bail Lordship by this honorable court Lordship. So that is the order number. Order is the page number 13 Lordship, annexure P3 Lordship.
No. You persons so obstructed the police persons
Yes,
to conduct the investigation, carry out the investigation. How?
Lordship, kindly para number 2 Lordship, 15 line Lordship. I tried to cordon the 2 houses, but I reached the escort inspection insufficient force. I was waiting for the additional force that time Lordship. MD Taslim, son of Samso, and MD Latif Samso Lordship, and others obstructing me from my government duty Lordship. Not this petitioner Lordship. They are obstructing to the duty of the government personal Lordship.
But however, they influence the villagers also. And at their inspection, the villagers also obstructed, and this police persons are not allowed to do their duty. 5 cattle there, the borderline, Indo-Bangladesh border.
And Lordship, HON'BLE and others, 4 others already granted bail by the anticipated bail Lordship.
Huh?
Page number 13 Lordship. HON'BLE and others Lordship. There is a 4 petitioners Lordship total. They are granted bail Lordship by this honorable court Lordship. I pay on the same footing Lordship.
No, there is no injury, madam. Only they have obstructed the.
The petitioner has filed the present application for grant of anticipatory bail. Grant of anticipatory bail. Full. The learned counsel for the petitioner submitted that the petitioners are not involved in the present case, but the police have implicated the petitioners falsely. He further submitted that one of the accused persons already been granted anticipatory bail by the coordinating of his court in CRM within bracket A 149 of 2026 dated 16th of May 2026. I Leonard, the APP in charge produced the CD. This could find that against this could find that produce the CD. After producing CD, this could find that the custodial interrogation of the petition is not required. Accordingly, custodial interrogation of the petition is not required. And thus this could incline to grant anticipatory bail to the petition. In the event of error, the petition shall be released upon furnishing bond of rupees 10,000 with one security. Each one petitioner, 2 petitioner.
4 petitioner Lordship.
10,000 with one security each of like amount, police stuff, like amount with the satisfaction of the arresting officer, police stuff. If with the condition that the petitioners shall cooperate with the investigation and shall meet the investigating officer once in a week till the final report is submitted. The petitioners are also, the petitioners shall not threaten or intimidate the witnesses of the incident. Yes, CRM services disposed.
Beautiful.
Next.
7.
behalf of the petitioner.
Let's come for the de facto. Appearing on
May I, my lord? May I, my lord? This is your my lord. My lord may come. This is a case of a cheating. The allegations made by the students are of siphoning of money. My
Who are
lord may
you?
come to the.
Who are you?
I am for the institute.
Huh?
I am for the institute. Director
No,
of
who
the
are the
institute.
petitioners?
Yes, my lord.
Who are the petitioner before this court? Who are the petitioner?
Directors, my lord.
They are the directors of
Direct.
the
Directors.
school.
My lord may come to page number 10.
They are the directors of the school.
Yes, yes.
Ah.
My lord may come to page number 10, whereby the written complaint lies.
Page number 10.
Page number 10. My lord may read it. I am waiting. My lord.
Page number 10.
10 onwards, 10 to 12.
10 is the order of the court.
No,
P1, order of the court, CRM 147.
Lordship, it is at page number 13. The written complaint.
13. ma'am. Yes, ma'am. I'm very sorry. It's page number 13.
Yes.
From page number 10. I'm very sorry. Very side karo. Pencil letter. Okay. Page number 13.
Writing the FIR to mention the serious problem regarding whatever has happened to the students of Asha Paramedical and Nursing Institute by whole management team. Surendra Kumar Bharti. He is the present, he is the director. And the petition number 2 is the Prem Kumar Chhatri.
Ma'am.
That is also director. Along with fellow assistant, I had joined the institute. Huh? Yes.
Reading the CD, serious allegations.
My lord, allow me to complete, my lord.
Yes, I will come. Yes.
Allow me to complete. My lord has finished, my lord. Now, my lord may come to page number 14, number 2. Point number 2. They promise us the degree of paramedical technician, but the degree they provided has mentioned that we have been certified just of a vocational training. Now, my lord may come to and my lord may see the name of the accused person at page name of the complainant at the page number 15. Now, my lord may come to P4, page number 16. The top heading, admission form, National Council of Vocational and Research Training, whereby the same complainant with signature and thumb impression. She willfully signed it. Now let us see the date of signing the admission form. It's 7/12/2000. It's কোথায় আছে signing টা? Huh?
8/8/25.
Yes,
Page 17.
Yes, my lord. 18/8/2025, and the letter of written complaint, my lord may see. It is at page
7
10.
February 26.
Yes. See, she is barred by estoppel of an act of acquiescence.
Why?
She herself, yes, because she herself has signed it, signed the admission form with a thumb impression, and now she is alleging that she will be given a vocational training certificate, whereby she has signed for vocational training certificate, and not only that, vocational sign certificate also includes paramedical technician, which I have also annexed from page number P7/23. My lord may see at 25 the list of degrees that they have been provided. Page number 23 is the degrees that are conferred through vocational training, and from page number 5, health and paramedical sector, all these things are provided. From page number 25.
What is this?
Brochure.
Brochure, yes.
Yes, brochure. So my lord,
Now she has come for a paramedical technician. She has signed for a vocational training. Now the vocational training also provides paramedical degrees. Now what problem she has, I am unable to understand.
No, she has made out a case that she have been informed that you will conduct the paramedical and nursing.
Yes,
Correct.
yes.
Correct.
No, no,
Along with the fellow assistants. When they join, the management team mentioned have the promise that the degree of paramedical, but the degree of provided is mentioned is the certificate to the
Vocational, and she has signed in the vocational training admission form with thumb impression. With thumb impression. Not that the signature can be later on copied.
Yes.
So the prosecution has to certify that the thumb impression is correct or not.
These are the actual.
Just, I mean, yeah, that's anything further?
No, nothing.
That's
Yes.
These are the advertisement or brochure, whatever, my lord. And online also, actually, these advertisements were given. And nursing training is also written there, my lord. Number one. Second is that, and we have already verified with the CMHO on the last page of our CD, my lord, is written, this is not a valid organization. It doesn't have any license. Last page. Like the last page of the CD, my lord. Backside. $150 students. The career has been ruined, my lord. It's a matter of 150 students. This type of organizations, this should not be entertained, my lord. They should be put behind the bar and custody. And this petitioner is the principal accused. And the other three accused who were arrested, they got statutory bail after 90 days. And moreover, criminal antecedent, we have taken a record, my lord. Criminal antecedent, they have a matter. This petitioner has another matter pending at Malbajar PS, case number 52 of 26, Darjeeling Sadar PS, case number 22-26, and Pradhan Nagar PS, another 127-26. This is the memo of evidence, my lord, where the IF has become a concise of the entire case. Serious allegations. 150 students, huge amount collected from them. Their career has been spoiled. And adding section 111 to organized crime, that is there of the BNS, my lord.
My lord, may I answer to this?
Yes.
My lord, right now, Mr. Prosecutor has mentioned that there are co-accused who have been granted bail after giving with a statutory bail. So now they have been granted bail because they could not find out something.
No, statutory bail.
Yes, my lord, because they could not find. And I am moreover relying on one
Somebody
judgment.
absconds and the other accused persons are granted bail. A charge sheet is filed. They come and say charge sheet has been filed. Investigation is filed.
May I?
Then the principal accused who is absconding.
Yes, the charge sheet with a period of supplementary charge sheet. My lord, may come to the one second, my lord. I am indicating the paragraph. My lord, paragraph number 12. I am relying on paragraph number 12. May I read it aloud, my lord?
Yes.
There is no gainsaying that the custodial interrogation is one of the effective modes of investigation into alleged crime. It is equally true that just because custodial interrogation is not required, that by itself may not be a ground to release the accused on anticipatory bail if the offence is of serious nature. However, mere assertion on the part of the state while opposing a plea of anticipatory bail that custodial interrogation is required would not be sufficient. The state would have to show or indicate more than the prima facie why the custodial interrogation of the accused is required for the purpose of investigation. My lord, we are ready to comply with everything. Even Manish Sisodia judgment, Supreme Court says, followed by the Arvind Kejriwal judgment, that bail is the rule, jail is the exception, my lord. My lord, may curb my liberty, my lord. I will not, with every stringent condition, my lord, I will comply, my lord. Because, my lord, one thing is there, my lord. They in the written complaint, they have specifically stated that they have applied for a certified post, not a vocational training institute. In the admission form, they have with thumb impression, the same complainant has applied for a vocational training institute. We have annexed all the certificates of our validity, my lord. The co-accused were granted bail, by the court below with custodial interrogation. Now, why they have been granted bail? Because nothing could be found out from there. That they did not file a prima facie charge sheet with a prayer for supplementary charge sheet, while on other investigations they come up with a charge sheet and with a prayer for supplementary charge sheet.
Okay.
Reply, my lord, the advertisement which they have given, and the form which those have been signed, there is also misrepresentation.
Misrepresentation with
They're
thumb
giving that we'll be giving you this course, and while signing, my lord, it's a fact, my lord,
That-
while signing, so on the ground, that 150 students, the future has been.
Then, my lord, the thumb impression has also
Your college is not registered college.
my lord, we have given the registration, my lord, in our petition.
There's a report. There's a report here.
My lord, may I just take up one
As per the
point?
Confirmation of the West Bengal Nursing Council, the institute has not been registered with the council.
My lord, may I just take up one point? No. May I take up one point, my lord? The state did not come up with the veracity of the admission form, the thumb impression of the admission form of the complainant. Now the
That is-
complainant is coming up.
That
It is not a matter of time, it is matter of liberty.
That is a good ground for you during the cross-examination at the defense stage.
My lord, my liberty, my lord, but that custodial interrogation may not be because I may be I may be called and every moment at the police station. I may not leave certain area and go, my lord. Kindly grants me because
But you are spoiling the society by giving the full document. See that you have published the advertisement. Persons went to your institution, got the admission, and you giving the certificate, and you are not recognized.
Hello.
See that. What is your answer on that? Tell me. I totally appreciate with the
My lord.
liberty bail. You cannot be interrogation is not required. All the things I totally appreciate with you.
my lord.
You only one answer a person knowing that he is not having the registration certificate, he is not having the all compliance of the state authority, but he is running the business, giving the advertisement, getting the admission and providing the certificate. Okay, I totally admit the certificate is also not signed by you. But what is the value of the certificate if the student will go for the job? What is the value of the certificate? It is not recognized. And you are providing the certificate to making the person's fool. See, give the answer to that. I am granting the anticipatory hearing now.
My lord, what we could gather is, my lord, the
Because
certificate
report
from
is
page
there.
number 27.
Report is there. Inquiry report has there. You have not been approved. The petitioner has filed the present application, praying for grant of anticipatory bail for the offence under section 316 within bracket 2/318 within bracket 4/338/336 within bracket 3/61 within bracket 2 of the BNSS 2023. Full stop. The counsel for the petition submit that the defective complainant herself has submitted the form for vocational training on 18th of August 2025, and on completion of the same, the institute had issued the certificate, but subsequently, after issuance of the certificate, has filed a false complaint before the police authority on the ground that the petitioner, the defective complainant, has got the admission for paramedical technician, but the certificate provided to the petitioner as a vocational training. Then a counsel for the petitioner has relied upon the document which is enclosed with the present application at annexure P4, wherein the defective complainant has filed her application for admission in the vocational training. Full stop. No, not full stop. He further submit that the petitioner had the knowledge, the complainant had the knowledge that she has applied for the vocational training, and on completion of the training, the certificate has been issued. Thus, there's nothing remains in the complaint, and the petitioners are entitled to get anticipatory bail. The petitioner has relied upon the judgment in the case of a special leave petition within bracket criminal number 9949 of 2023 within bracket Ashok Kumar versus Union Territory of Chandigarh, and submits that that the prosecution merely cannot pray before this court that the custodial interrogation is required. The court has to see with regard to whether the custodial interrogation of the petitioner is required for the investigation. The Leonard APP in charge is present along with the IO and produced the CD. He submitted that the institute had issued has published an advertisement under the heading Asha Paramedical and Nursing Institute for admission and placement in medical laboratory technology, ICU technician, OT technician, nursing and midwifery within bracket ANM, radiology and imaging technology, dialysis technician and physiotherapy technician. He further submitted that after initiation of the case and submit that during the investigation, the investigating officer has requested the concerned authority whether the institute of the petitioners have been registered with the state authority or not. On the request of the investigating officer, the authorities have submitted the report wherein it reveals that as per the confirmation from the West Bengal Nursing Council, the institute is not registered with the council. Learned Council appearing for the state further submitted without the registration of the institute, the petitioners are advertising petitioners are taking the admission in their institution and providing the certificate without any approval of the state government. Consider the submission made by the council for the respective parties, peruse the matters on record and the CD. This court find that the petitioners were running the institute without the approval of the government and issuing the certificate. And as such, the certificate, and as such, the custodial interrogation and the further investigation is required to go into deep in the matter. Thus, this could find that this is not a fit case for grant of anticipatory bail. Accordingly, anticipatory bail CRM census is dismissed.
Lordship, on indulgence, kindly record the de facto's presence, Lordship.
Census
Grateful, my lord.
Next. 8. Yes. Who? Victim.
However, on the charge sheet, section 12 of TOPSO
Good. Next.
14.
Let's say I for the petitioner.
Yes. Mr. Chakravarti, tell your bar. I am finding in many of the criminal division, whatever it may be, either rate or criminal division or civil division, the parties, this court granting the entry mode for certain time. Okay, I appreciate because the circuit is for only for the 12 days or 14 days, whatever it may be. Once you know that your entry mode is going to be expired, instead of filing an application before 2 days of the circuit, mention so that matter can be, because I find it is
Rather filing of a CRAN within the limitation, within the interim period, if they can file an application or if they can mention also.
not required for extension of entry mode. Once you enjoying, I don't think it is required for the entry because it is the burden.
But now I will come in the other side. There are two things. One is
No, that
regarding,
I appreciate
and
that.
for us also, for the lawyers, for the prosecution, if there is a CRAN, we can also raise the bill.
Now, I appreciate that because now you will get the name in the order sheet. There is no problem. Because yesterday I found you mentioning, so 10-15 matters are cramped. So time is wasting. So that time can be.
My lord, definitely, my lord. My lord
Please
is,
say to the bar.
my lord will talk.
Please talk to the bar.
Because is the senior lawyer is here.
Yes, that's what.
That is a supplementary.
Yes.
Worship, that is the relaxation application. Relaxation on the relaxation.
Where is the order?
Order
Which
is on
order?
page number 8.
Page 8. Anticipatory.
Anticipatory.
When
Shall-
it was granted September 2024, according direct to Iman Douglas, witness shall be released on bail.
With a condition.
Condition
15.
shall meet the investigating officer once in a week.
Once in a
13.
So,
charge sheet has
filed.
been. Charge sheet filed.
Yes, Mr.
My relaxation, my lord, I leave it.
Charge
my
sheet
lord.
filed.
My lord, I leave it. It's a discretion of the court, my lord. I won't
The
interpret.
petitioner has filed the present application being CRAN 1 of 2026, praying for relaxation of the bail condition granted by imposed by this court on 11th of September 2024 in CRM within bracket A 630 of 2024, wherein this court has directed the petitioner to meet the investigating officer once in a week until further order. Counsel for the petitioner submitted, investigation has been completed. And during the investigation, the petitioner has complied with the direction passed by this court and has filed the supplementary affidavit disclosing the document showing that he has complied with the direction passed by the condition imposed by this court. In view of the above, the condition imposed by this court by an order dated 11 September.
আমি তোমাকে লিস্ট দিয়ে দিচ্ছি সব বের করে দিতে
Is relaxed.
Grateful to
এগুলো
election.
আমার কাছে আছে
CRAN is disposed of.
তুমি আগে এখান থেকে ভাগ করো গাছ কাটে আমাকে
Next.
15. Oh, I don't know if I'm paying for 1 day accommodation.
Why?
My lord, I have-
CRA,
yes, my lord, bail in connection with the appeal. That is why.
not today.
Great to me.
চল যাই গিয়ে বসাক
16.
Yes. 16, who is appearing? What is the matter? CRA. Nobody is there?
I'm praying for not today.
Not today.
Worship, I think the matter is running under the wrong heading. It should be under application for suspension of sentence.
That's why I'm asking, what is the application?
For suspension of sentence.
CRAN.
Plan 2.
Similar, the previous was also bail in connection with that.
Bail in connection with.
Yes.
Okay, no. Not today. Next.
17, I am appearing.
17.
I am appearing for the appellant, Worship. Your Lordship has taken up this matter a day before yesterday. That notional income.
Who is for the other side?
Lordship, day before yesterday, Mr. Partho Bhomik was appearing for the insurance company.
Yes. You are for the
I'm for the appellant claimant, Lordship.
appellant claimant.
Mother of the deceased.
Yes. Father,
Mother.
mother of the deceased.
Deceased.
Where is the award?
Lordship, the award is page 39 onwards.
Now, which portion you are have grieved? Only the monthly income?
Lordship, notional.
5,000.
Notional.
Notional.
Yes.
Where is the insurance company?
It will be passed over, Lordship.
Pass over. I will take this matter, inform the other side.
Lordship.
Pass
I
over.
called him, maybe he is in the lower court.
Pass over.
18.
Eighteen. Pass over.
19.
Go give. I will not leave. I will dismiss. No problem. In the last occasion also none of this. Which item? Item number?
19.
One KB paper book is there. No, they have some other paper. That is the problem. Why you are not giving the paper? I am searching here. Bill in connection with the appeal. What is the bill? It is fine from the record. Since the month of January 2025, none appears on behalf of the petition appellant. The appellant has filed an application being CRAN 1 of 2024 and CRAN 1 of 2021. Praying for disposed of. एक काम करो इसको ना ऑफिस में भेजो नॉट टुडे करो ऑफिस में भेजो यस नेक्स्ट 20
My lord, I am on behalf of the petitioner. Service, affidavit of service. My lord, this case is special leave to appeal.
हाँ
Special leave to appeal, my lord.
Special
Under
leave to appeal.
under section 378 subsection 4 of CRPC, my lord. My lord, there is a CRAN application.
just a
The-
minute where is the judgment which judgment you have filed an appeal is
My
a
lord.
complaint case
Complaint
138
case. NI Act,
138.
my lord. Complaint case NI Act,
138
138.
so accused has been acquitted
Acquitted, my lord.
where is the judgment of acquittal
My lord, section
where is the
Ah.
judgment of acquittal
2 April,
huh
2 April 2025, my lord.
huh
2nd April
where is
2000.
that where is that where is the page number
My lord, certified copy. Annex, I have annex certified copy, my lord.
of CRA
CRA.
CRA?
CRA number 578 to 2023.
where is your criminal appeal where is your appeal where is the appeal you not file appeal
My lord, I have
where is the appeal number
9, my lord.
huh
9.
there's a criminal special leave what is the CRAN one
CRAN one is the limitation.
CRAN one where is the
Section.
appeal কি
My lord, I
হচ্ছে
have not
জলপাইগুড়ি without the child you are asking for the maintenance
My lord,
sir you are not filed the appeal
my lord.
without the appeal how where the leave will be granted court has to see the appeal ground judgment once your criminal special is allowed then the criminal appeal will be admitted your appeal is not here which will be admitted if the leave is granted
My lord, 1 day accommodation.
what you will do
My
one
lord,
day
my lord, the appeal will file.
The petitioner has filed the present application being CRAM CRM as special 9 of 2025 praying for special leave to prefer an appeal against the judgment and order passed by the learned. Where is the judgment and order?
My lord, 2nd April 25.
Just a minute. No. 2nd April.
2nd
Today
April
speaks for
2025.
so cause by the complainant. Accused is present. Complainant takes no step. No so cause has been filed. The discharge. Where is the acquittal? You have not appeared.
My lord.
So against the discharge, where the appeal will lie.
My lord, Honorable Justice Tirthangor Ghosh.
So, yes, what if doesn't draw direction? File appeal.
Pass an order. Observe that the case acquittal as the section 279. That is why I filed the petition, my lord.
But inside of the leave, you not understand the order passed by the court. The petitioner has filed an application being CRM special 9 of 2025, praying for special leave to prefer an appeal against the order dated 2nd April 2025. The petitioner also filed an application being CRAN 1 of 2025. 1 of 2025 or 6? 2025. 5 for condoning the delay in filing an application being CRM 9 of 2025. This court find that the petitioner intend to get an special leave from this court to prefer an appeal against the order dated 2nd April 2025, wherein the accused has been discharged from the case. But the petitioner has not preferred any appeal against the said order. Only an application for special leave and condonation of delay is filed. Counsel for the petitioner prays for leave to file an appeal.
Good.
Let the matter appear on?
My lord, next week, my lord.
On 21st.
Get my lord.
21st. If the petitioner file any appeal, the same will be tagged along with the petition, along with this case record and to place before this court. Next.
I am on behalf of the petitioner.
21. वो जो पेपर बुक वाला बोला है ना, सब में आने को criminal section को लाने. Yes.
Yes, ma'am.
Criminal motion.
Yes.
Yes.
It's a new motion, madam. I am aggrieved by the order dated 31/1/2026, which I have annexed the certified copy. Now, my lord, this is a domestic violence case, madam. The petitioner hearing are parents-in-law, mother-in-law, father-in-law. Now, they appeared in the domestic violence case and they filed an application under section 27 stating that the DV case is not maintainable before the Siliguri court. Why, my lord? Because before filing the DV case, my lord, she has already filed a DV case in Jalpaiguri court, my lord. And she withdrawn that case stating that the matter was amicably settled. And after 5 days, my lord, thereafter she again filed this instant DV case. Writing in her DV petition in page number 20, stating that her present residence is in Siliguri, my lord. My lord, if your lordship sees section 27 of the DV Act, my lord, it speaks about temporary residence, my lord.
Yes, sir. DV Act with that. Domestic violence act.
Just one line. May I read out? Should I read out?
Yes, read.
Yes. Jurisdiction. It says that the court of judicial magistrate of the first class or the metropolitan magistrate, as the case may be, within the local limit of which the person aggrieved permanently or temporarily resides or carries on business or is employed. Now over here she says that she is temporarily residing in that Siliguri jurisdiction. My claim is that, my lord, she, just to bring the jurisdiction of the Siliguri court, has written that address and have filed the case. Now, my lord, before going into the judgments, my lord, I have few documents, my lord, which the petitioner requires to adduce through evidence, my lord. What has happened, my lord? This 27 application, mental material application has been given, and the court had closed the issue by stating that in her application she has stated that she resides within Siliguri jurisdiction, and hence this case is maintainable, my lord. But however, the jurisdiction is a question matter of facts and law, my lord. And the present petitioner happens to reside in Sikkim, not in Siliguri, my lord. She is running a business in Sikkim of medicine, my lord, and she also has deed of partnership, and she also agrees to the same fact, even in an application stating that she used to run a medical shop in Sikkim, but now she is not running. But as per the contention of my petitioners, my lord, there are sufficient evidence. She has also given a complaint before the Jorthang police station stating that she has misled the court by stating that she is a resident of Siliguri. I have several evidence of the people, my lord, residing in Jorthang who has stated that she's been residing in Sikkim for the last 10 years.
Where is the order of magistrate?
At the end, madam. Magistrate, madam. Magistrate. That's in page number 33, madam.
Which she look.
Yes.
Yes, my lord.
So,
So, my lord, she states in her application that she is residing in that address, my lord.
Hmm.
But I have enough proof to prove that
Hmm.
that she is not residing in that address, my lord.
Hmm.
Now, my lord, I would like to rely on a judgment of Bombay High Court, my lord, which describes the definition of temporary jurisdiction, residence.
Hmm.
That's in page number para 13, my lord, starts. And it says, para 13,
yes.
it says that it was observed that temporary residence,
Para 13.
para 13, my lord.
Ah.
It was observed that temporary residence does not include residence in a lodge or hotel or residence at a place only for the purpose of filing a domestic violence case. My case rests over here, my lord.
Correct, but the London magistrate has stated that the complainant category stated that she has been hosted and she is residing in the rented house.
Now, she was first residing in a parental house,
Correct.
my lord, and
Then
thereafter,
they have not been welcome in the parental house and she is residing in the rented house.
my lord, that, and I have ample proof, my lord, that residential address, which it doesn't exist, firstly. Secondly, my lord, that she only for the purpose, my lord, of filing the domestic violence case has stated that address.
Correct.
But
See,
presently,
so-
she's residing
so
in
that
Sikkim,
is-
my lord.
But you could have been taken all the things in the written objection, but you filed the 27 application. The 27 application, the court cannot go into the merit of the
My lord,
matter.
my limited
You
prayer,
could have been taken all the things in your written objection.
absolutely, my lord. My limited prayer is that that jurisdictional point may be kept open, my lord. And after the evidence, my lord, this may be decided by the trial court. Nothing more, my lord. I'm not seeking anything, nothing more than that.
But you have filed the application that has been decided. What can be done?
My lord, that jurisdiction point has been closed, my lord. That is the problem, my
Who is
lord.
for the other side?
That
Some
would-
notice.
Yes, my lord. The notice is required to be
They're
served.
here, no.
No, this is the first time. I'm
No,
doing.
whether they are residing here, you can serve the notice by this week.
My lord, this address is a problem, my lord.
I will not stay. I will not stay.
No, I don't want to stay, my lord, in
Ah.
this case. It should not be stayed, my lord.
Hmm.
So the thing is that, my lord, the service, I will also make a service, my lord, and if the service may be made through the police also, because they will not find the address, my lord. That is why I was saying.
No, what is the address mentioned in the cost title?
The address, this address, many notices have gone into this address, my lord, and nothing, it has returned back. Address not found. That is why I was saying, my lord, kindly, my lord, direction for service may be given, and my lord, if it could be served to the police also. As your lordship pleases, I have no problem, my lord.
The petitioner has challenged and filed the present divisional application challenging the order passed by the London Judicial Magistrate 4th Court, first class Judicial Magistrate 4th Court, Jalpaiguri, Siliguri.
No, Siliguri.
Siliguri. Dated, what is the date?
The date is 31/1/2017.
Dated 31st of January 2017, and the judgment passed by the London Additional Session Judge 2nd Court, Siliguri, in criminal appeal number 9 of 2017, dated 31st of January 2026. Full stop. This court is full stop. The petition is directed to serve the notice upon the opposite parties, and to file the affidavit service on the next date fixed. This is the matter on 21st. Next, 22.
Please, my lord. My lord, I appear for the petitioner, my lord. My lord, the factual metrics of the present case, my lord, unfolds on 9th of September 2019, my lord, when the prosecutrix sent a email to the superintendent of police, Sadar Police Station, Darjeeling, my lord, to the effect that around when she was 14 years old, my lord, her tuition teacher, that is the present petitioner, my lord, he sexually molested her, my lord. On the receipt of the said complaint, my lord, on 11th of September 2019, FIR number 171 of 2019 came to be registered, my lord, under section 354, 376, 511, 377, 503 and 509 IPC, my lord. And the concerned sections, that is section 3, 1, 10, 11 and 12 of the SC/ST Act, my lord. My lord, post the registration of the FIR, my lord, one main charge sheet, my lord, under the said sections, my lord, and a supplementary charge sheet was filed, my lord. And thereafter, my lord, on 17th of October 2023, my lord, I moved a discharge application, my lord, in the said case, wherein, my lord, I was discharged under section 377, 376 and 511 IPC, my lord, whereas charge was framed under 354, 509 IPC and the provisions of the SC/ST Act. My lord, am I audible, my lord?
Yes, continue.
Please, my lord. Please, my lord. Thereafter, my lord, the cross revisions were preferred in relation to the said charge, my lord, by the prosecutors, my lord, as well as the petitioner, my lord, before this honorable court, my lord. And while order dated 5th of September 2024, my lord, the honorable court was pleased to dismiss my revision petition, my lord, and allow the one filed on behalf of the prosecutors, my lord. And an additional charge under section 376 was ordered to be framed against me, my lord. My lord, said order was impugned before the Honorable Supreme Court of India, my lord, wherein by order dated 16th of December, my lord, 2024, the notice was issued, and subsequently, my lord, on 26th of March 2026, the leave was granted. Since, my lord, there was no stay of the proceedings, on 4th of Feb 2026, my lord, the London Trial Court framed additional charge as mandated in the Honorable High Court's order, my lord. Now, my lord, coming to the grounds on which I seek the quashing of the present FIR, my lord. If your lordship would for a moment see, my lord, the complaint was preferred on 9th of September 2019, and it says, my lord, that the prosecutress at that time was 36-year-old, and when she was 14 years old, my lord, that goes back to 22 years, my lord, it is alleged that the petitioner sexually abused her. Now, my lord, there is an inordinate and unexplained delay of 22 years in lodging the present FIR that has not been explained anywhere in the entire prosecution story. In this respect, my lord, if your lordship for a moment come to section 114G of the Evidence Act, my lord, if your lordship would have section 114, my lord.
Are you very serious about this application? Once the coordinate bench has modified the order passed by the London district judge or sessions judge by directing to frame the charge under 376, now you can again file an application for quashing.
Please, my lord.
Satisfied this on that.
Please,
second thing, whether the said matter is pending before the Honorable Supreme Court, whether this court can take up the matter at this stage.
Yes, my lord. Allow me to satisfy your lordship on
Sorry.
that count,
Sorry.
Lord, allow me to satisfy your lordship on that count, my lord.
No, I am not satisfied.
No, my lord. Let me put forth my contentions, my lord. Then your lordship may take the appropriate call, my lord. Please, my lord.
You filed an application before the London Session Judge for discharge.
Yes, my lord.
London Session Judge has discharged you, not framing the case under section 376.
Please, my lord.
377. Correct.
Please, my lord. Correct, my lord.
Correct.
Correct,
Then
my
the
lord.
complainant or state whoever it may be came before this court challenging the order of the session judge.
Yes, my lord.
And this court held that no section that also to be added.
Yes, my lord. Yes, my lord.
Correct. Now,
Yes,
challenging that order, you filed the SLP and SLP is pending.
Yes, my lord.
Now,
Lord,
your
if-
contention is that in spite of pending the SLP, the trial court has already framed the charge by incorporating the section and proceeding with the trial.
No, no, lord. That is not
Now
my
you-
contention. My contention is this, my lord.
Now
My
you
contention.
filed this present application challenging the FIR. Once
Yes,
the
my lord.
total
The
contention has
present
been taken
application,
up
my
by
lord,
this
if-
court in
No, no, my lord. If your lordship would appreciate my contention, my lord, the application which was moved before this honorable court earlier, my lord, that pertains to the order passed by the session judge in relation to my lord, the framing of charge as well as the discharge cross
Correct.
revisions were filed. Now, my lord, the
Correct.
scope which the court has to appreciate at the stage of framing of charge is very different, my lord. The court has to see if there is a grave suspicion for the commission of the offence. While in a case where I seek the quashing of FIR, my lord, your lordship has to see whether there has been a prima facie abuse of the process of court, one, my lord, whether on the bare perusal of the facts, my lord, any offence is found to be committed. Third, my lord, if the allegations are absurd and inherently improbable, so that no sane person can come to a conclusion that the proceedings can be continued. And, my lord,
Yes.
there is another criteria as spelled out in the judgment of Bhajan Lal, my lord, that when the proceedings are dominantly attended with mala fide, my lord, they have to be quashed. So the my lord, horizon, legal horizon at the stage of quashing is quite wide, my lord. And while as at the
Okay.
stage of charge, my lord, your lordship has only to see whether there is grave suspicion as emanating from the record for the accused committing the offence in question. So, my lord,
To you satisfied this court, you filed an application 227 before the trial court for discharge.
yes, my lord.
Correct.
Yes, my lord.
No case is made out, that's why discharge.
Yes, my lord.
And the court has not discharged you.
The court had discharged
Will
me.
not discharge you.
Had
not
discharged me
discharge you.
qua certain sections, my lord, and qua certain sections they framed the charge.
Correct, but subsequently that has been set aside. No matter is pending before the Supreme Court.
Yes,
No
my lord.
comments
But
on
in
that.
relation
Comments
to
on-
whether the offences
Now
are
tell
prima
me-
facie, my lord, if I may
Now
explain
tell
myself, my
me
lord.
that
Please, my lord.
that now you can say that there is no case made out. That's why the FIR is to be paused.
My lord, there is no case made out, my lord, as is, my lord, I am squarely falling within the parameters as spelled out by the Honorable Supreme Court in State of Haryana versus Bhajan Lal judgment, my lord. I have quoted the relevant paragraphs. If your lordship would straight away come to...
Is in the case of the Bhajan Lal whether prior 227 was filed, thereafter the
No, no, my lord.
482 was
No,
filed.
no, no, that was not the scenario, my lord, but the parameters where the quashing has to take place, my lord, they have been spelled out, my lord,
Sir,
and I
that's
squarely
why I
fall in
am
that criteria.
again I am telling that,
Please, my lord.
informing you that with regard to quashing, you have to satisfy that no case has been made out.
No, no, my lord, that is one of the criteria which has been spelled out in Bhajan Lal judgment, my lord. There are other parameters under which the court can quash. That is only one criteria. That's why, my lord, I was urging that in relation to the charge,
The
my lord, the
petitioner
scope
has
is
filed
different.
the present revisional application challenging the proceedings of
If your lordship would for a moment
challenge.
come to para 23 of my petition, my lord, page 9, my lord.
Sir, you are satisfied how once the court has already held and this court has, the coordinate bench has held that the 376 is to be added. How the quashing will now come?
My lord, only to that and your lordship, I'm taking your lordship to para 23, my lord. That will satisfy your lordship in relation to that. Your lordship may have para page 9, my lord, of my petition, my lord, para 23.
Yes. Yes, tell me.
Your lordship has para 23, my lord, at page 9.
Yes. Yes.
Please, my lord. My lord, it says, my lord, that Honorable Apex Court in the case of State of Haryana versus Bhajan Lal, my lord, reported so and so, has laid down the parameters. Now, my lord, your lordship may come to E, my lord. Para E, my lord. E says, my lord.
Yes.
Where the allegations made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion and there is sufficient ground for proceeding against the accused. I'm relying on this, my lord, and your lordship may come to G on the next page, my lord. G says, my lord, where a criminal proceeding is manifestly attended with mala fide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Now, my respectful submission, this, my lord, now this parameter which is spelled out and postulated in G, my lord, where a criminal proceeding is manifestly attended with mala fide, this parameter cannot be dealt with by the Honorable Court at the stage of charge, my lord, while appreciating the arguments on the point of charge. Because there the only scope is this, my lord, whether grave suspicion exists for the accused committing the offence in question. Now, my lord, the
Hmm.
parameter and legal horizon at the stage of while appreciating the mandate of 482, my lord, is quite wide, which is manifestly clear from reading of these two provisions, my lord. One which says, my lord, that the contents are absurd and inherently improbable. That is also not the scope
Correct.
under charge, my lord. And second, my lord, under G, it says the proceeding is manifestly attended with malafide. Now, this portion also, my lord, cannot be dealt with while appreciating the mandate of charge or discharge, my lord, under the relevant sections. Now, my lord, if your
Correct.
lordship would for a moment have the concerned judgment in, if your lordship would straightway come to ground 5, my lord, on page 15, my lord.
Yes.
It says, my lord, for that the delay herein in ordinate and as played, the Honorable Supreme Court of India in Suresh Garodia versus State of Assam held that we find that lodging of a case after 34 years and that too on the basis of a bald statement that the prosecutors was minor at the time of commission of offence could itself be a ground to quash the proceedings. No explanation whatsoever is given in the FIR as to why the prosecutors was keeping silent for a period of 34 years. Now, your lordship, for a moment come to section 114, my lord, of the Evidence Act, my lord.
What is the new section for the now? एविडेंस एक्ट আছে ना होगा नहीं तो हम लोग तो बस 5 बजे घर चले जाओ. What is the section in the BSA?
Lord, in BSM, Lord.
Yes, 144. Tell me.
Please, Lord. It says, my lord, 114, my lord, explanation G, my lord. It says, my lord, that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. In the present case, my lord, there has been a delay of 22 years in lodging the FIR. There is no explanation in relation to this delay. So, my lord, the adverse inference needs to be taken under this section that the offence in question never happened. That's why so much delay occurred in relation to the commission in reporting of the incident. Now, your lordship, if your lordship would come to ground 6, my lord, page 16.
Yes.
Now, my lord, it is the case of the prosecutors as is unfolded in the complaint, my lord, that after 22 years, she was prodded to lodge the present FIR, my lord, because she has come to know that there were certain school children who are still being abused by the petitioner, my lord, and that's why she has come forward to register the case. Now, my lord, neither she has provided any details of the school children, my lord, nor those details have surfaced during the course of the investigation. Now, that is the very fulcrum of the prosecution case, my lord, which prodded the petitioner to come forth and lodge the FIR. And that very fulcrum being rendered non-existent, my lord, that FIR is bound to fail. If your lordship would have page 26 for a moment, my lord, the complaint. Page 26, my lord, unnumbered para 2.
Where's the page 26?
Running page 26 of the petition, my lord.
Where is page 26?
And except P1, my lord, page 25 starts with page 25, it is the FIR, my lord. On page 26.
It is in envelope.
अब खोलता तो उसको सील नहीं कर, दूसरा केस में उसको फिर टैग करके रख दी. खोलिए खोलिए.
Your lordship has page 25 and 26, my lord, and except P1.
Just a minute, just a minute. Just
I'm sorry, my lord. Your lordship has the relevant page, my lord, 26.
Now you put in the seal cover. Now my officers is taking out the same from the seal cover.
My lord, it is
You
not in
put the
seal.
FIR.
Yes,
The seal cover.
Okay.
As because 370 allegations there.
I'm sorry, my lord, I was not aware about the procedure, my lord.
Yes,
Please, my lord.
page 20.
My lord, page 26, my lord.
Yes.
My lord, may come to second unnumbered para, my lord. It starts with by way of this information report. I wish to report it to you that when I was 14-year-old child, my tuition teacher Jitesh Oja sexually abused me for more than a month at my then residence so and so, my lord. Now it says, my lord, it has taken me 22 years to develop the immense courage and conviction needed to report this horrific crime to you. Now come the basis which prodded her, my lord. As I have come to know that he still continues to work as a teacher and abuse young school children. Now, my lord, this is the very fulcrum which prodded her to come forward and lodge the FIR. Now, my lord, neither the details of the school children have been provided by the prosecutrix, nor these details have surfaced during the course of the investigation. And now, if your lordship would appreciate a bold statement, my lord, that 22 years back this thing happened, my lord, without giving any timeline as to date, time, place, or year. How can I defend a charge like this? If your lordship for a moment come to, my lord, section 11 of the Evidence Act, my lord.
Yes.
It says, my lord, when facts not otherwise relevant become relevant. Now, your lordship may come to illustration A. Illustration A says, my lord, that question is whether A committed a crime at Calcutta on a certain day. The fact that on that day A was at Lahore is relevant. Now, my lord, this is the section from where the plea of alibi or the defense of alibi springs forth. Now, my lord, in a situation where no date, time, place, or timeline is mentioned, my lord, the entire prosecution is precluding or forbidding me to take that defense. They have blocked my statutory defense available under the law. Because in this kind of situation, my lord, I cannot take that defense. If I have to take that defense, my lord, I have to take it for the entire duration of a year. That comes to 22 years back.
Then, where is your 227 application filed earlier?
Blood
Application is not annexed.
Where is the 227 application?
Lord,
Where is the
application
order
is not attached, my
227?
lord. The concerned order passed by the honorable court is there, my lord, at page.
No, where is the 227 application and the order passed by the London
Lord, order
Sessions
passed
Judge?
order passed by the High Court is as page 56, my lord.
That is there, but where is your application?
Application not annexed, lordship.
Lord, the application has not been annexed, my lord.
So then you come to the paragraph 6, page 61 of your writ petition and original application. Judgment of the order of the coordinate bench of this court.
Yes, my lord. Page 61, which para your lordship wishes me to read, my lord?
The last 3 line of the first para.
Yes, my lord. We are now concerned if due delay in filing of the FIR, the criminal proceedings against the accused person should be quashed or not. The reason for delay is well explained and comprehensible. Now, my lord, if your lordship would say, would appreciate, my lord, one, my lord, this revision was against the order on charge which was framed by the London trial court. So the scope was very different. Second, my lord, the court has not returned any finding as to whether the complaint lodged by the prosecutress is attended with manifest malafide. My lord, when there is so much delay, my lord, and when the
Now come to the page. Now come to the page 62, paragraph 14.
Please, my lord. This court is inclined to test if there is that is so improbable to render the entire FIR and the criminal proceedings against the petitioner as vitiable. Delay in FIR as a standalone factor. My lord, delay their lordships have considered in relation to disposal of the petition, my lord. But the delay vis-a-vis the parameter provided in
So only,
Bhajanlal
only,
Milord
only
as to
change,
whether the
I
complaint
only
was
change,
attended.
only change the provisions of the CRPC. Can you raise the same question in the second
No,
proceeding?
no, no. The question is not same. Milord,
That-
delay is something different. What I am relying
You-
on is the
that-
parameter of section.
Just you are telling that the 22 years delay FIR, 22
No, no,
years,
Milord. That is
14
one of
years,
the
whatever
contentions.
it is.
If your lordship would for
That-
a moment come to page 23, Milord. For a moment come to page 9, Milord. Para 23. In fact, page 10, Milord. Para G, page 10.
Yes.
It says, Milord, the last parameter of the Bhajanlal judgment, Milord, where a criminal proceedings is manifestly attended with malafide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Now, Milord, this has not been
Correct.
dealt with by the Honorable Court while disposing of my petition. And this is borne out from the fact, Milord, that the details of the school children on the basis of which she came forward and lodged the present FIR explaining the delay, those details neither have been provided by the prosecutrix nor collected by the police during the course of the investigation. Again, Lord, section 114G would come to my rescue. That had those children been examined, those children would have made submissions that, Lord, no such thing happened. That would be the only deduction that would be coming forth from non-examination, my lord. Because, my lord, if your lordship would appreciate, she has not come forth because she has been raped. She came forth, my lord, because she came to know that certain other school children are also being abused by the petitioner presently. That is what goaded her forward to lodge the complaint. And those details are absent from the record. That has not been dealt with in the entire order anywhere, my lord. And that is the malafide.
Okay. That's all.
And if your lordship would for a moment come to page 19, my lord, I have quoted Haji Iqbal's judgment, my lord. That would be very relevant in the present scenario, my lord. Page 19, my lord. It says, my lord, for that the Honorable Supreme Court in Haji Iqbal versus State of UP and others, my lord, has observed that offense of rape causes great distress and humiliation to the victim. However, a false allegation of rape can cause equal distress, humiliation and damage to the accused as well. It was further observed that in frivolous or vexatious proceedings, the court owes up duty to link into other attending circumstances emerging from the record, and if need be, with due care and circumspection, try to read in between the lines. The Honorable Court observed that while exercising powers under 482, the Honorable Court is empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the other materials collected during the course of the investigation. That, in fact, widens the scope of the mandate of 482, my lord, while disposing of this kind of a petition. And that has not been considered by the lordships, my lord, while disposing of my revision petition. And that is squarely comes within the last parameter of Bhajanlal.
Okay. That's all?
That's all.
It occurs. Charge sheet paper. How you have staged this? I am dismissing hearing now. How the court will read?
Please, Lord.
You have access copy of the charge sheet? PDF of the court will go. Which court, where you are practicing? Then you don't know. Huh? What? You persons are who has taken this? You are having access copy of the charge sheet. You are not a physical copy. Why? You are not having brief. खोलो। The petitioner has filed the present revisional application praying under section 528 of the Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the FIR and proceeding, as well as the order dated 2nd February 2026, passed by the learned special judge under SC/ST Act, additional district and session judge within bracket first court at Darjeeling, in connection with special GR case number 30 of 2021, arising out of Darjeeling Sadar Police Station case number 171 of 2019, dated 11 September 2019, under section 354/376/511/377/503/509 of the IPC, read with section 3 within bracket 1 within bracket X/XI/XII of the SC and ST Act 1989. 1980, full stop. The contention of the petitioner in the present application that the victim has made a complaint to the Superintendent of Police, Sadar Police Station, Chowk Bazar, Darjeeling, on 9th of September 2019, wherein she has mentioned that by way of mentioned that semicolon, inverted comma, italic, by way of first information report, comma, I wish to report you that क्या बोला? And 19, and on the basis of this said complaint, comma, the police has registered the above mentioned case against the petitioner, and on completion of investigation, comma, the police has submitted charge sheet against the petitioner, full stop. The petitioner has filed an application under section 227 of the Code of Criminal Procedure for discharge of the petitioner from the said case. The learned special judge has disposed of the said application by deleting the section 376, 377.
Please,
all.
Lord. Please, Lord. And 511.
These are the two. Only these two sections was deleted by the learned session judge when the first time.
3 sections, Lord, 376, 377, and 511.
511 have been deleted, and it was directed to proceed with the trial against the petitioner for the offense under section 354/503/509 of the Indian Penal Code, read with section 3 within bracket 1 within bracket X within bracket SI within bracket XSI of the XII of the SC and ST Act 1989. Full stop. Being agreed with this order of the learned sessions judge, a special judge, comma, the petitioner as well as the victim have preferred two criminal revisional application before this court, being CRR 347 of 2023 within bracket Jitesh Oja versus State of West Bengal and CRR 13 of 2024 within bracket victim versus State of West Bengal. Both the revisional application was taken up by the coordinate bench of this court and by an order dated 5th of September 2024, this court directed the trial court to incorporate the charge under section 376 of the IPC and to commence the trial on charge including section 376 of the IPC. 376 of the IPC. Being aggrieved and dissatisfied with the order passed by this court, by the coordinate bench of this court dated 5th of September 2024, the petitioner herein had preferred an SLP before the on the Supreme Court, and the same was admitted and the on the Supreme Court by an order dated 24th of March 2026, leave is granted and the matter is pending before the Honorable Supreme Court. Honorable Supreme Court. What is the interim order? Interim order to continue. What is the interim order?
No interim order, my lord.
No interim order. Full stop. ठीक है जी? Full stop. Now the grievance of the petitioner and full stop. Full stop. Learned counsel appearing for the petitioner submits that the matter is pending before the Honorable Supreme Court whether the charge under section 376 can be framed against the petitioner. But the learned special judge, where is the order?
Blood.
Continuing the. But the learned special judge has framed the charge against the petitioner under section 376 within bracket 1 within bracket small f of the IPC and proceeded with the trial for examination of by examining and proceeded with the trial. Now the petitioner has filed the present application for under section 582 of the BNSS for quashing of the proceeding. Full stop. Learned counsel for the petitioner submits that as per the judgment passed by the Honorable Supreme Court in the case of Bhajanlal, reported in AIR 1992 SC 604, in an application under section 482 of the Code of Criminal Procedure, or article under Article 226 of the Constitution of India, the court has to see the allegations made in the FIR or complaint are so
absurd and inherently improbable.
Or complaint whether the said allegations are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. Learned counsel for the petitioner further submits that in the said case, the Honorable Supreme Court has further held that in a criminal proceeding, it is manifestly where in a criminal proceeding manifestly attend with a mala fide and or where the proceeding is maliciously instituted with an ulterior motive for working vengeance on the accused and with a view to spite him due to the private and personal grudge. Full stop. Learned counsel for the petitioner further relied upon the judgment in the case of Suresh Garodia versus State of Assam and another reported in 2024 volume 12 SCC 150 and submit that in the said case the Supreme Court has held that lodging a case after 34 years and that too on the basis of a bald statement that the prosecutrix was a minor at the time of commission of offense, could itself be a ground to pause the proceeding. Full stop. Learned counsel for the petitioner has further relied upon section 144 of the Indian Evidence Act and submit that 114 of the Evidence Act and submits that as per clause G, the evidence which could be and is not produced would, if produced, be unfavorable to the person who withhold it. Full stop. By relying the said judgment and the provisions of the Indian Evidence Act, learned counsel for the petitioner draw the attention of this court to the complaint dated 9 September 2019 on the basis of which the FIR has been registered. He submitted that in the FIR it is categorically mentioned that the complainant has made the report. In the complainant categorically stated that when she was a 14 years old child, her tuition teacher Jitesh Oja sexually abused her for more than a month at her residence and had taken her around 22 years to develop the immense courage and conviction needed to report his horrific crime. Full stop. In the complaint, it is also mentioned that she came to know that the accused still continues to work as a teacher and abuse young school-going children. Full stop. The counsel for the petitioner, by referring the said paragraph of the complaint, submit that it is admitted. Admittedly as per the complaint made by the complainant, the alleged incident was occurred when the victim was 14 years of age. Now the victim has filed the case on 9th of September 2019. That is about 22 years after. Thus, from the face of record itself, shows that the case initiated by the complainant is barred by linkage. That is after the period of 22 years. Full stop. The full stop. Learned counsel for the petitioner further submit that admittedly the petitioner has filed an application under section 227 of the Code of Criminal Procedure before the London Trial Court for discharge of the petitioner, comma, the same cannot debar the petitioner to file this application and file another application for quashing of the FIR and the proceeding. He submitted in the application under section 227 of the Code of Criminal Procedure, the only grievance of the petitioner that no case has been made out with regard to the offense alleged in the charge sheet. But in the present revisional application under section 482, now 528 of the BNSS, comma, the petitioner has raised the question with regard to delay in lodging FIR after the period of 22 years, and the complaint made by the complainant is improbable, for which the prudent person cannot come to the conclusion that the petitioner has committed the offense at any point of time. Full stop. Full stop. Had sapera. Had the learned counsel for the petitioner peruse the materials on record and the judgment relied by the petitioner. Full stop. The complainant has made a complaint to the superintendent of police, Sadar Police Station, Chak Bazar, Darjeeling, on 9th of September 2019. On receipt of the complaint, comma, the police has initiated an FIR and proceeded with the investigation. After the investigation, the police has come to the investigating authorities come to know the complaint made by the complainant is correct, and prima facie case has been made out against the petitioner. Accordingly, charge sheet has been submitted. On receipt of the charge sheet, comma, the petitioner has filed an application for discharge for the offense alleged in the charge sheet. Full stop. As the petitioner has not disclosed the application filed by the petitioner under section 227 of the Code of Criminal Procedure, but from the order of this court, last paragraph, and an application 227 of the CRC. The London Trial Court, after hearing the petitioner and the prosecution, has passed an order by deleting section 376, 377 and 511 of the IPC. 511 of the IPC. But when the said order was challenged before this court in the revisional application by the state as well as the victim, comma, this court has held that the 376 is to be proceeded and charge under section 376 is to be added, and the trial is to be proceeded along with the section 376 of the IPC. Now the petitioner has relied upon the complaint. Now the petitioner, by relying upon the complainant, by relying upon one of the paragraph in the complaint, which reads as follows. Eta kori den. Page 26. Okay. The contents of next para. The contention of the petitioner that from the complaint itself shows that the alleged incident was occurred when the victim was 14 years of age. Now, what is the age of the victim now?
36 years, my lord, at the time of lodging the report.
Now, 14 years of age. And when the victim has made this complaint on 9th of September 2019, the victim was
36 years.
about 36 years. Thus, the victim has made the complaint to the police after the period of 22 years.
Yes.
22 years. Full stop. He submits full stop. 22 years. Full stop. He submits that. He submits then get it. Full stop. 22 years. This could find that the police has submitted charge sheet. The police has submitted charge sheet. Police has submitted charge sheet. Charge sheet on 7/7/2021. And after submission of the charge sheet, the same was supplied to the petitioner. On receipt of the charge sheet, the petitioner has filed an application under section 227 of the CRPC for discharge. But the London Special Trial Court, instead of discharging, only deleted the section 376, 377 and 511 of the IPC. When the order passed by the London trial judge was tested before this court in the criminal revisional application by the state as well as the victim, this court has also dealt with the ground of limitation. Ground of limitation. Full stop. In paragraph 14 of the judgment dated 5th of September 2024, the coordinate bench of this court has held that the said order is under challenge before the Honorable Supreme Court in an SLP preferred by the petitioner. Full stop. Now the petitioner has relied upon. Now the petitioner, on the basis of the judgment, relying upon the judgment of Bhajanlal within bracket Supra and Suresh Garodia Supra, has filed the present application. In the case of Bhajanlal, the Honorable Supreme Court has held that the allegation made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. This said fact was duly argued by the petitioner at the time of discharge of the petitioner, at the time of hearing of the petitioner, at the time of hearing of the application filed by the petitioner before the trial court for discharge. The trial court has also taken into consideration of the said aspect, but the trial court has not discharged the petitioner. Only the 376 offense under section 376, section 376 of the 311, 377 and 511 was deleted. This court in the order dated 5th of September 2024 has categorically held that delay in FIR as a stand-alone factor may not be sufficient for pausing the proceeding. If the allegations prima facie have constituted a cognizable offense and are not so severely improbable. Full stop. Considering the above, this court find that on full stop. This court find that once the petitioner has taken the chance for discharge from the said case by filing an application under 227 of the CRPC. More or less, the petitioner succeed in the said application for deleting 3 sections. But subsequently, this court in a revisional application has added section 376 and directed the London trial court to proceed with the matter along with the section 376 of the IPC. Now the London trial court has proceeding with the matter by framing the charge under section 376 of the IPC. Considering the above, this court is of the view that only to drag the matter from one court to other court, one provision to another provision, the petitioner has filed the present application. Having the knowledge that earlier 227 application has been partly allowed, which was subsequently modified by this court, and now the matter is pending before the Honorable Supreme Court. Considering in view of the above, the CRR number so dismissed. In view of the above, this court did not find any merit to admit the present revisional application. Accordingly, same is dismissed.
Please.
ओइटा पेज का देखकर अंदर डाल के स्टिच करवा देंगे. चल चला है बुइट
23.
You're appearing.
No, I'm for item number 24.
None appears on behalf of the petitioner. None appears on behalf of the petitioner. No accommodation is sought for. This court finds that the petitioner has filed the present application for recalling of the order dated 29th of July 2024, wherein this court has dismissed CRR 71 of 2023 for default. Today, when the matter is called, it is fine from the record that since after the filing of the revisional application, one or the other ground, the petition has taken time. Even on 29th July 2024, none appears on the petition. This court has dismissed the revisional application for default. Today they filed an application. Today also the petitioners have filed this present application for recalling of the order dated 29 July 2024, but none appears on behalf of the petitioners. None appears on behalf of the petition. Accordingly, CRAN 1 of 2024 is dismissed for default. Next.
24 to 28.
Your Lordship, I am for the petitioner. I am led by Mr. Shah in this matter.
Yes.
This is the matter about a wife who has lost 4 affairs against the husband. 4 identical, almost identical affairs, but with contradictions here and there against the husband, and in one of the affair against the husband, his mother, and 2 sisters also. Previously, your Lordship was pleased to link all this matter. There are 5 matters. Your Lordship was pleased to link all this matter together to be heard. Lordship, I am being led by Mr. Shah in this matter. However, some difficulties, he is unable to appear before your Lordship today. Kindly fix this on Monday, your Lordship.
How many matters will you fix on Monday?
Lordship,
Especially fixed today then? On the 12th May, not appeared. And this court is special fix. It is made clear that on the date fixed and appears on behalf of the petitioner, visa application will be decided on merit.
No, Lordship.
So today's fixed. Now you are asking the time. Yes.
Your Lordship, actually, he is moving this matter. That's why I'm asking.
Maybe he may be doing, but when the matter is listed, it could have been appeared before the court.
Yes, Your Lordship. One last chance may be
See?
given on Monday.
How many chairs have you counted? Why this court has been established? Only for putting the chairs and tables.
I apologize, Your Lordship. As a last chance, one last
Argue,
chance.
otherwise I will go through and I will pass on. Nothing.
No,
My order, 2025, I pass an order to clerk the matter.
Yes.
And you file this revision application 2023.
Yes.
Since 2023, it is going on.
Oh, there was a problem with the client also regarding the
Maybe
client.
the client is having problem. What the client will do for the revision application? What the client will do for the revision application? Is there any stay?
There was a stay.
So I am vacating and directing the trial court to continue with the.
No, Your Lordship. Your Lordship, kindly
Just-
pass it over.
just miss-
Your Lordship, kindly passes it over. Let me communicate him. He will be.
Nothing
He
doing.
will be. He will
You are
be able
enjoying
to.
the stay order, I am vacating the
He
stay
will
order.
be able to. That has been that has been already exhausted, Your Lordship. So far as I remember. Kindly gives me a passover. Let me communicate with Mr. Shah. He will be appearing. Give me 15 minutes at least, Your Lordship.
No. 15 minutes. The court
Because
will
there
not
is a
sit.
merit in
Where
this
are the
matter.
other matters?
Your Lordship, there is merit in this matter. That's why Your Lordship,
Sorry.
I'm pressing. Your Lordship, kindly, Lordship. Your Lordship, kindly. Your Lordship, due to Reeves 13B application was filed by both the husband and the wife. After that, she became absent in that particular court, Your Lordship. Thereafter, the petitioner himself filed a divorce petition. But after that, Your Lordship, she has lost this FIR confidence. Repeatedly 4 FIRs. Your Lordship, kindly gives me time. Let me communicate with him, Your Lordship. 15 minutes at least.
2 years you got the time, you are not ready, then I will pass a proper.
Your Lordship,
Record an order.
15 minutes, Your Lordship. Let me
This
communicate, Your
court
Lordship.
find that by an order dated 8/8/2023,
Lordship, kindly,
the
Lordship.
proceedings of GR case number 4742/2021 arising out of police station case number 819 of 2021 dated 7th October 2021 under section 498A/323 of the Indian Penal Code IPC pending before the Learned Court of Judicial Magistrate, Third Court at Siliguri State for a period of 4 weeks or until further order, whichever is earlier. Subsequently, by an order dated 14th of August 2024, the interim order extended for a period of 8 weeks or until further order, whichever is earlier. Thereafter, the matter was appeared on several occasions, several dates, but the interim order is not extended. It is also find that time and again when the matter is fixed, one or the other reason the counsel for the petitioner takes time instead of arguing the matter. Accordingly, the learned magistrates, the learned Judicial Magistrate Third Court at Siliguri is directed to proceed with GR case number 4742 of 2021 pending before 2021 in accordance with law pending disposal of the instant division application along with Magistrate. According to London Judicial Magistrate.
Is directly to process. According to
Proceed with the GR case number 77, comma. London Judicial Magistrate third court Siliguri. At Siliguri. और ऊपर वाला क्या था? वो भी थर्ड कोर्ट सिलीगुड़ी, ये भी थर्ड कोर्ट सिलीगुड़ी, पर ना थर्ड कोर्ट सिलीगुड़ी is directed to proceed with the GR case number 4742 of 2021, 2021, comma. (4742) है ना, और comma GR case number 3329 of 2021. GR case number 2895 2024. तो अलग है all four cases you are enjoying.
We are not enjoying stay.
Then,
There was a stay and that exhausted me.
that's why I am directing to immediately conclude at the time.
Lordship,
Mr. Shah is-
I'm for the petitioner.
Mr. Shah is-
GR case number.
Lordship, I'm for the petitioner. May I be permitted to allow?
What?
Lordship, I am for the petitioner.
Yes. So you are watching that what the court will do, then
No,
you
no.
will come when
No,
the court is going to pass the adverse order.
No, absolutely not, Lordship. Just now, my clerk has intimated that your Lordship is taking up the matter. That's why I came to know, Lordship. That's why.
So you don't know why you're not take the list?
No, Lordship. I could not. I was engaged in other court, Lordship. Don't take me amiss.
No,
Lordship.
yes, junior is not told that you're engaged in some other court. You're telling that you want
He
some
was not
time.
He was not aware of about the current position of mine. That since I was engaged in other.
Okay, what is the matter?
Lordship, that the petitioner and the de facto Lordship, the petitioner and the de facto complainant, the opposite party number 2, had a marriage. He just checkered history regarding their matrimonial dispute and all. Lordship, that the couple of litigations was held. The series of litigations was pending with the learned court below, as well as in Honorable High Court as well. Lordship, that out of that, Lordship, the present petitioner, he is the husband who has suffered.
Just which is the first matter?
110.
110.
CRR number?
110.
Huh?
110.
110.
110. Yes, 110. Where is the FIR? Where is the FIR?
The affairs, the impugned order, Lordship, the impugned proceeding, kindly see.
Where is the FIR? Where is the FIR? What is the number of the FIR?
FIR number is, Lordship, Pradhan Nagar Police Station, case number 819 of 2021. 819.
FIR number?
819.
CRR 110.
Yes.
110/23.
Yes.
Yes. FIR number?
819 of 2021.
819 of 2021.
Yes.
Dated 7th October 2021.
1.
PS?
498
Pradhan Nagar.
Pradhan Nagar.
Pradhan Nagar. Under section?
498
498A 323 IPC.
Yes, Your Lordship.
Yes, this is first.
Yes.
And another 111.
111, Your Lordship.
Yes. CRR 111 of
Siliguri woman-
2023.
Yes.
Where is the FIR? Which page?
The next one, Your Lordship.
Siliguri Women Police Station.
Yes. Yes. 99
Yes,
of
yes,
2021.
yes, Your Lordship.
FIR
Siliguri-
99 of
99 of
2021.
2021.
Dated
27th of
27/7/2020.
1.
2021. Under section?
498.
PS?
Your Lordship.
PS Siliguri Women Station.
Yes. Yes.
Siliguri Women Police Station.
Women Station. Women Police Station.
Yes, Your Lordship.
Yes.
Yes. Dated
Dated for
under section 498A.
498
498A,
448
498A 448
379,
379
506.
506 IPC.
Yes, Your Lordship.
Yes. Then I what is the number?
CR number
260.
260.
260. Yes. CRR 260 of 2023. Yes. FIR number, where is FIR?
FIR number, Lordship.
Your Lordship.
Just a minute. The FIR number 110, first one.
Yes, yes.
Which court is this pending?
It is pending in Judicial Magistrate Third Court at Siliguri.
JMFC. Third court.
Yes, Your Lordship.
Third court,
Siliguri.
Siliguri. Yes. And second one?
Second one also same.
Same court.
Yes, Your Lordship.
JMFC.
Third Court.
Third court,
Siliguri.
Siliguri. Yes. Then third one. Third one.
Siliguri.
260.
Yes, Your Lordship. Siliguri Women Police Station case number.
Just a minute. Yes, CR 260. Where is the FIR?
Your Lordship. Your Lordship, FIR number. Siliguri Women Police Station case number 99 of 2021.
Where is that?
It is at page number.
'99 or 2021?
Yes, Your Lordship.
99, 2021. No, that is the same.
It is the same one.
Same one.
Same one. Well, in this matter, we are for the mother of the petitioner, mother and two sisters.
So, CRR 110 and 260 of the same.
Same FIR, Your Lordship.
260 of same.
Same FIR, Your Lordship.
Correct. Then
492 CRR 492.
CRR
492.
492. '92 of
2024.
2024.
4.
FIR, where is the FIR?
Your Lordship,
Pradhan Nagar.
Pradhan Nagar Police Station case number.
Where is that?
That
Page
is
number?
at page number. Your
Where is the
Lordship.
page number?
Yes, Lordship.
Yes, FIR
FIR number
FIR
529
29
2024. Dated 18th August 2024.
Yes.
Under section
under section, Your Lordship.
498A.
325.
Then 325.
Your
Five.
Lordship. 498A, 448,
448.
427,
427.
379,
379.
and 34 of the IPC.
34 IPC. Which court it is pending?
Your Lordship, it is pending in Chief Judicial, Learned Additional Chief Judicial Magistrate.
ACGM.
Yes, Your Lordship. Siliguri.
ACGM.
Yes, Your Lordship.
And is a Pradhan Nagar.
Pradhan Nagar, same police station case.
Nagar PS.
Yes, Your Lordship.
ACJM, where is
Yes.
that? ACJM?
Siliguri.
Siliguri.
Siliguri, yes, Your Lordship.
ACJM, Siliguri. Yes.
Then,
And another?
Your Lordship, 494 of 2024.
494, 2024.
Yes, Your Lordship.
Yes. FIR, same.
No, Lordship.
No, no.
I think it's
529.
Lordship, it is different.
Same,
Case number 529.
same case.
Same case. Lordship. 5. No, Lordship.
Yes.
Lordship, it's different. That was 764.
Which one?
The 492 one was 764.
What?
The FIR number in 492 was 764.
No, 529.
29.
Page 13. Page 13 of the CRR.
No, kindly see the cost title. Kindly see the cost title, first page. 764.
529. 529.
Your Lordship, no, Lordship. In here, the
CRR 492.
Yes, Your Lordship.
Kindly come to the first page cost title.
First page cost
Interim
title.
proceeding being general register case number so and so, PS case 529 of under section so and so. Pradhanagar PS. This one.
No,
This is
Lordship,
CR 492.
I'm telling
And
you,
this one.
494.
Lordship,
And this one. 494.
Pradhanagar PS case number 764.
That is a 764. 494 FIR 764 2024. Dated 26/11/2024. Yes. Where it is pending? CJM, ACJM.
494, Your Lordship.
ACJM, Siliguri. Yes. So I am passing an order. All the
Lordship?
all the 5 cases be taken up by the one court.
Lordship, I have a argument, Lordship. This is
Nothing.
a- Lordship,
Nothing.
Lordship, kindly
What?
allow me, Lordship. Lordship, kindly allow me, Lordship. The petitioner is suffering this litigation one after another.
Correct. That's why instead
No,
of all the court,
all are quashable.
the petitioner has filed this.
Lordship, kindly allow me.
The
Lordship, kindly-
petitioner,
Lordship,
the
Lordship,
petitioner has
kindly enough.
filed-
Lordship, kindly allow me. Lordship, kindly allow me. Lordship, kindly be kind, Lordship. Be
filed
kind.
the
Lordship, be
5
kind.
criminal revisional application
Lordship,
being
kindly-
CRR 110 of
Lordship, may-
2023, comma
Lordship, may
CRR number 111 2023, CRR 260 of 2023,
Lordship, kindly allow me.
CRR 492 of 2024, and CRR 494 of 2024
Without
on
merit.
the allegation that
Lordship,
the
without merit.
wife of the petitioner has initiated FIR number 819 of 2021 dated 7th October 2021 at PS Pradhanagar under section 498A/323 of the IPC, and the said case is pending before the Judicial Magistrate First Class Third Court at Siliguri. Good. Wife of the petitioner has initiated FIR number 819. The wife had again lodged an FIR, being FIR number 99 of 2021, dated 27/7/2021 at PS Siliguri Women Police Station, under section 498A, 448, 379/504 of the IPC, and the same is pending before the JMFC court at Siliguri. So JMFC third court at Siliguri. Police. It is the wife of the petitioner has lodged another FIR other FIR being FIR number 529 of 2024 dated 18/8/2024 under section 498A oblique 448 oblique 427 oblique 379 oblique 34 of the IPC at PS Pradhan Nagar, and the such case is pending before the ACJM Siliguri. The wife of the petitioner has again filed an FIR, again made a complaint, before the police of which PS? FIR 764. Before the police of PS Pradhan Nagar, dated 26/11/2024, under section 85 oblique 329 within bracket 4 oblique 324 within bracket 4 oblique 303 within bracket 2 oblique 3 within bracket 5 of the Bharat Nyaya Sanhita 2023, and the same is pending before the London Additional Chief Judicial Magistrate, Siliguri. Full stop. Learned counsel for the petition submit that time and again the wife of the petitioner has initiated several cases against the petitioner for the same offences, due to which the petitioner is facing great difficulties, and thus the petitioner has filed the present divisional applications for quashing of all the proceedings initiated against the petitioner. Full stop. The counsel for the petitioner further submit that one CRR in which the mother is the party, in which the mother is in which case CRR
260.
CRR number 260 of 2023 is filed by the mother-in-law of the complainant for quashing of the FIR, which is connected with FIR number 260, connected with FIR number 99 of 2021 dated 27/7/2021 of PS Siliguri Women Police Station, pending before the London Chief Judicial Magistrate Third Court at Siliguri. Full stop. The only grievance of the petitioner in all the criminal application is that only on the basis of the complaint of the wife of the petitioner, the police authorities have again and again registered the case and submitted the charge sheet without considering that already the complainant has, already the wife of the petitioner has made a complaint and investigation has been completed and charge sheet has been filed. Considering the above, this court finds that the only grievance of the petitioner that the wife has initiated altogether 4 FIRs, 5 FIRs, 4 FIR, 5 FIRs, and all the cases are pending before the different courts, due to which the petitioner is facing difficulties. In view of the above, this court direct all the cases, all the above cases be placed before the London ACJM Siliguri, and the London magistrate is directed to proceed with the trial analogously with regard to all the cases, and to dispose of the case as early as possible within a period of as early as possible without giving any unnecessary adjournment to any of the parties. CRR number disposal.
So it will take 10 years. It will take lordship 10 years to conclude, because there are almost 50 witnesses are there, 50.
Okay, okay, no problem.
Magistrate, Lordship, my client is already mentally retarded because of this barrage of proceeding between
Yes.
the parties. Kindly
Next.
allow me, Lordship, write
29.
all the possible matter.
Yes, next. 29.
29, Your Lordship. Mr.
Yes.
Shah, Mr. Shah is leading this matter.
Yes. What is on 29?
Lordship, sound unmute.
Yes, what is the 29?
Your Lordship, 29, Your Lordship. You challenge the notices, Your Lordship. He is unmuted, Your Lordship. That's the problem.
Yes, Mr. Shah, you are appearing. Unmute, unmute.
Yes, Lordship.
Yes, what about the
Yes.
29?
Lordship, this matter was earlier heard out by the coordinate bench, and Lordship, after hearing the matter, Lordship was pleased to direct the state to produce the case diary. On the last, kindly see the order. Kindly see the order dated.
By which order? By which order?
24th of March. 24th of March 2026.
2026, 24th of March.
Yes.
Let me see. Then concept of the prays for time to obtain instruction. Instruction. What is the matter?
No, the case, the state was directed to produce the case diary on the next date.
Not
Please.
case diary. Only take instruction, obtain instruction.
Last
What
line,
is the
last line. Kindly see. Last line. Let the
Yes,
state
but-
produce the case diary.
What is the case diary? Yes. They are not producing the case diary. What is your case? What is your case?
I may be allowed to argue personally on the Monday, in person, on Monday.
You
only
are taking chance.
certainly not.
Sending the junior before the
Absolutely.
court. Okay, you
Absolutely.
go and take. Once
Absolutely
the court
not.
has
Lordship,
stood
I am
by
not-
not
Lordship,
giving, now started appearing before.
I must be honest and candid to your Lordship. Don't take me.
Mr.
Lordship,
Shah, please avoid this practice. Otherwise, it will be very difficult to use, sir.
Lordship,
Please
don't
avoid
take me.
this practice with regard to the bench hunting. Please
Yesterday,
avoid
Lordship,
the practice.
yesterday I did it. The 3 matters before your Lordship. Why should I avoid the court, Lordship? Yesterday I personally appeared before your Lordship.
That is
Lordship
not with
disposed of
regard to
on merit.
the matter.
Lordship, I did it. The matter, 3 matters.
Not today.
Yesterday.
Oblige, Your Lordship.
Next.
Lordship personally. Lordship, I'm just requesting your Lordship to appear Monday.
None appears on behalf of either of the parties. No accommodation is sought for. Full stop. It is fine from the record. It is fine from the record. Since 25th of April 2020, petition was sent. Since 11th November 2024, none appears on behalf of the petitioner. Today also, when the case is called, none appears on behalf of the petitioner, no accommodation is sought. For the interest of justice, the case is adjourned. Let the matter appear on 20th May 2026. It is made clear that on the date fixed, if none appears on behalf of the petitioners, the revisional application will dispose of on hand. The state is directed to be present along with the CD on the date. The department is directed to forward this order to APP in charge for compliance. Which matter?
Number 80.
Item number
88.
18.
18.
Yes. You are appearing for?
Claimant appellant.
18 that.
Yes. Who is for the other side?
Other side is insurance company, but none appear on behalf of the insurance company. This is a difficulty. The paper book is also ready.
Which company? Which insurance company?
Oriental Insurance Company.
Have you issued the notice? The service is completed.
Paper book already in section 5 application. I have already served the to the insurance company. The affidavit.
Where is the affidavit of service?
It's kept in the record.
February 25.
Yes, I have filed the section 5 application memo, all the. But
That was
still
allowed.
That
Section 5
section
allowed.
5 as allowed.
Ah.
There was a direction to.
What is the ground for? What is the ground in appeal?
The ground for the appeal is this is for the enhancement of the amount. The,
For what? What ground? Under what
the
ground?
ground of the income,
Ah.
Learned Tribunal has only decided the amount of rupees 3,300 per month.
Ah.
But I am being a driver.
Hmm.
The notional income as per the on the basis of
Driver of private company.
driver
Private vehicle.
private.
Ah.
So my that the income should be at least 6,000 per month.
Ah.
There are serious series of judgment I can, my lord, I can produce it. That the notional income at least may be fixed.
How the notional income is to be taken into account? How the notional income is to be calculated? How the notional income? How the notional income is to be calculated, sir?
On the
Ah.
basis,
Oriental, which area? This insurance company having office where? Kolkata?
sir, at Jalpaiguri also. Branch office also at
Division
Jalpaiguri.
office, the post office, Jalpaiguri.
Jalpaiguri
Ah.
also.
Okay, issue notice. Record. Where is the paper book?
Paper is ready.
Filed. Learned counsel for the appellant is present and file paper book. Let the same be kept with the record. The none appears on behalf of the insurance company. The petition is directed to inform the next date of. Have you served the paper book with the insurance company?
Paper has none appears.
The
Direction may be
counsel
given
for the
that-
appellant is directed to inform the next to serve the copy of the paper book and to inform the next date of hearing to the insurance company. List the matter on 21st May. The petition directed to file affidavit of service on the next date fixed on the returnable date. So and come.
Appearance.